All right, good morning, everyone. Welcome to Notre Dame Law School. My name is Nicholas DeAndre, and I'm editor-in-chief of the Notre Dame Law Review. And it's my pleasure to open today's symposium on liberalism, Christianity, and constitutionalism. The conversations we're going to be having today, of course, have been going on for centuries, but it's increasingly become more prevalent as the law has challenged our moral, philosophical, social assumptions, baselines. And so we have a really esteemed group of authors today to discuss this topic, and we're really excited to have them publish their work in a forthcoming issue of the Notre Dame Law Review. So before we get into the actual content of today, I want to say a few quick thank yous. So first of all, thank you to the Emory Center for Law and Religion and to the McDonald Agape Foundation for their sponsorship and support of this symposium. It really wouldn't be possible without them. And especially thank you to Professors Nathan Chapman and Professor Kathleen Brady for their support. And they are the chairs of our symposium. And really without their advice and guidance, we wouldn't have the phenomenal panels that we have today and the great scholarship that is forthcoming. Secondly, thank you to Professor Rick Garnett and the Program on Church, State, and Society for their sponsorship of this symposium, and especially for the phenomenal dinner we had last night. We had a really great fellowship, some great conversations, and it was a really good way to kick off this symposium. And lastly, but certainly not least, thank you to the Notre Dame Law Review staff, specifically Megan Flanagan and Courtney Klaus, who have put in tons of time in their organization and preparation, are really why we have such a great breakfast here this morning. Everything has been running smoothly today, and so thank you so much for their help. So with that, I just want to let everybody know that the program is being recorded today and will be available online after the symposium. But I will step away and invite Professor Chapman and Professor Brady to come up and share a few words. So please join me in welcoming them. Thank you.
I think Nicholas did an excellent job of thanking everybody on my list. So I don't have very much to add other than to thank Nicholas and Courtney and Megan in particular, and all of the staff, of course, of the Notre Dame Law Review. Smooth is a perfect word for how everything has been handled, and we could not be part of this without all of their hard work. And of course, to all of our participants who come from far and wide, we're really grateful that you're part of this conversation. And Amy Wheeler is sitting over there representing the Center for the Study of Law and Religion. We're very grateful to them, and for Peter McDonald and the McDonald Agape Foundation for making this possible.
Thank you. I don't have anything especially witty or exciting to say about the topic today, other than to say that it occurred to me not long after we put the idea of a symposium for liberalism, Christianity, and constitutionalism together that it is difficult to imagine three concepts that are more contested, that raise more diversity and in some ways hot feelings amongst folks, and trying to do them all three at once sounds insane. I am very gratified that the early drafts of the papers that we've received, there's a lot of interesting overlaps and echoes and gestures of one another's papers already without even engaging directly with one another's papers. I think you'll see that expressed in the panelist discussions today. I want to say a special thank you to my friend Paul Billingham, as this is my first time seeing you here at the symposium. Paul, I can see you, but no one else can because you're on the back wall. Thanks for joining us from Oxford. It's it's really wonderful to see all of you. Thank you for being here. I hope that you enjoy it, and I'm really looking forward to hearing from my friends, old and new. So enjoy.
Thank you. And for the first panel, we'll invite up our first panelists. And I want to also thank and welcome Professor Paolo Carrozza, Professor of Law and Concurrent Professor of Political Science here at Notre Dame. All right, first panel, please.
Yeah, please feel free to take her. Just take those two and there's one down here. And I'll slide over to the end. So great. Good morning, everybody. It's a real privilege to be here and to be able to moderate this first panel with such a wonderful group of guests to Notre Dame and such a great collection of challenging, stimulating papers that give us a lot to think about and a lot to engage with. So my job is to get out of the way as quickly as possible and turn it over to you, to the panelists, so that you can really hear the most of these very substantive presentations. And for that reason, I'm also going to keep these introductions extremely short. I'll introduce the four panelists right from the start and then turn it over to them. We're aiming for about 12 minutes per presentation, which will leave us some time for engagement and questions with all of you as well. So the first speaker will be Professor Nathan Chapman, who you just heard from a moment ago, who is the Pope F. Brock Associate Professor in Professional Responsibility at the University of Georgia Law School. Professor Chapman's scholarship focuses on the historical and theoretical underpinnings of constitutional law, especially the law of religious liberty and due process, and he's also written a number of essays on Christianity and law. Professor Andrew Koppelman, a pretty regular visitor to Notre Dame over the years, and we're privileged to have him back as the John Paul Stevens Professor of Law, as well as a Professor of Political Science and an affiliated faculty member in the Philosophy Department at Northwestern University. His scholarship, which includes more than 100 scholarly articles and 8 books, focuses on issues at the intersection of law and political philosophy. Then we'll hear from Professor Brandon Paradise, an associate professor of law and the Professor Dallas Willard Scholar at Rutgers Law School, who's also affiliated with the Institute for the Study of Eastern Christianity at Union Theological Seminary. His research interests are in religion and law, race and law, and the intersection of these three: race, religion, and law. His paper has been co-authored with the Reverend Dr. Sergey Trostyanskiy, an Eastern Orthodox priest, rector of St. Gregory the Theologian Church, located on the campus of Union Seminary, and also part of the Institute for the Study of Eastern Christianity, and the author or editor of several books on Eastern Orthodox theology. They'll be sharing their time of presentation, so I think Professor Paradise will do most of the initial presentation, but Reverend Trostyanskiy will be available also for the discussion and dialogue afterwards. So thank you very much, gentlemen, for being here for your presentations. And without further ado, Nathan, I'll turn it over to you. You're welcome to stay seated if you want, or to stand up if you're more comfortable.
Yeah, I think I'll stand. It's a little easier for me. So I'm beginning today. I've been told basically last things are first today, because my talk is about the way that United States constitutional law has incorporated, I think unwittingly, but incorporated ideas of Christian eschatology into doctrine and certainly into theory. Christians believe that Christ will come again to judge the living and the dead, that some are bound for eternal blessedness, some perhaps not. And the study and doctrine within Christian theology about these matters is designated eschatology, last things. And scripture and teachings of eschatology are somewhat unclear. It's one of the difficult things about the future is that it can be hard to predict. And Christians have divided over the years, sometimes quite violently, over their beliefs about eschatology. My approach in the essay is somewhat archaeological. It would be genealogical, I think, if I had done it from the past to the present, but I want to start by foregrounding what I think the evidences are of Christian eschatology in constitutional law, and then work backwards to what I suspect are the influences that have led to this. So I'll begin with constitutional law. I'll talk about how I think that this probably reflects most proximately a doctrine within American civil religion that maintains that America has a unique moral destiny in the world to bring about more justice, more equality, both domestically and externally. And I'll talk about what I think are some of the key historical movements of particular churches, particular intellectual streams that have contributed to that civil religion that then I think has been relied on to incorporate these ideas into American constitutional law. So probably one of the clearest statements of the idea that US constitutional law should reflect a notion of America's moral destiny was given by Justice Brennan extrajudicially in a speech he gave at Georgetown University. I'm going to quote, "If we are to be a shining city upon a hill, it will be because of our ceaseless pursuits of the constitutional ideal of human dignity. As we adopt our institutions to the ever-changing conditions of national and international life, those ideas of human dignity, liberty, and justice for all individuals will continue to inspire and guide us because they are entrenched in our Constitution. The Constitution, with its Bill of Rights, has a bright future as well as a glorious past, for its spirit is inherent in the aspirations of our people." Here, Brennan is very directly drawing on a tradition within American civil religion that conceives of the US as a city on a hill with a unique moral destiny to the world. And he's directly tying it to the US Constitution and to the court's duty to interpret and enforce the Constitution. He makes that plain in other parts of his speech. Not all justices, of course, believe this. And my claim is certainly not that the court's doctrines throughout reflect this sensibility, but some of them have, and some of them continue to do so. It's been one theme, and it's often been contested by folks who disagree with it. So consider the evolving standards of decency doctrine as a way to interpret the Eighth Amendment. I argue the idea of eschatology is on the 10. It is the label of the doctrine itself. Justice Kennedy's opinion in Obergefell relies heavily on the idea that new eras have new insights into the meaning and the scope of liberty, and it's the court's responsibility to implement it. There's similar rhetoric in the Lawrence opinion. And I think a similar sensibility underlay, although it was more nascent at this point, the court's opinion in Brown versus Board of Education, and its many decisions incorporating the standards of the Bill of Rights against the states. So again, this is not pervasive in American constitutional law. It surfaces more overtly in some cases than others, but it's a major theme, and it's probably a much broader theme among theorists. I think it's a pretty widely regarded assumption about constitutional law and the way it should be interpreted, based largely on the influence of Ronald Dworkin and general commitment to left liberalism in the academy. So where does this come from? In the first place, I think it comes from the American civil religion. The civil religion, for those of you who haven't studied this, I don't have time to go into detail, basically is an idea promulgated by sociologists and theorists of religion that America has its own religion that has its own series of symbols and doctrines and rituals and beliefs often associated with the things you may associate generally with patriotism. And my argument, and this is supported by lots of those theorists, is that one of those doctrines is that America has a special moral destiny. A separate one of those doctrines is that the Constitution, the Declaration of Independence, perhaps a couple of other specific speeches by presidents or something have a kind of status as sacred scripture. And what I take the court to have been doing beginning in the 50s with the Warren Court, especially Brennan, some people say it should be called the Brennan Court, and as well as some more recent cases, is to be adapting this and secularizing it for purposes of US constitutional law. I've also identified at least 4 or 5 different streams of particular history of and experience of religious life in the United States that I think contribute to this feature of our American civil religion. And in other words, why is it possible for so many Americans to generally accept this feature of American civil religion? It's because so many Americans have some aspect of that sense of America's destiny as part of their own particular religious traditions. Initially, the most influential of these was probably a kind of Protestant evangelicalism, the postmillennialism in the 19th century, liberal Protestantism of the late 19th, early 20th century, influenced by Hegel, sort of implemented this in a slightly different register. American pragmatism through the influence of Dewey, who even more secularized Hegelian philosophy of history was responsible for this. And in some ways, it sort of reached its pinnacle, at least for purposes of American civil religion and the merger in the 1950s and 60s with the civil rights movement and the Black clergy, especially MLK, repeatedly asserting that the arc of the moral universe is long, but it bends towards justice. And for King, there was a sort of rich and sophisticated Christian eschatology that was underlying that, but that sort of seeped into American civil religion and was reflected in the speeches of presidents and other figures in that era to the present. I want to conclude by my remarks today just by mentioning a couple of contributions I think this paper hopefully will make. One is it widens our understanding of the influence of religion, especially Christianity, on constitutional law. Its methodology is pretty unique. I'm not sold on it yet. I'm not totally sure that it's right, but it's fun to play with, and I'm open certainly to your critiques and suggestions on it. Maybe more importantly, it raises a question about what eschatology may or should look like without God. I mean, I'm positing here that the constitutional law has incorporated some secularized notion of eschatology. Appeals to abstract justice are subject to great dispute, of course. And the problem here is somewhat akin to secularized theories of human dignity and human rights. I mean, it's the same kind of issues arise. To what extent are these coherent and susceptible of actually guiding judgment without underlying theories of anthropology and theology that initially animated them? They may work, but I think they have some heavy lifting to do to compensate for the loss of their traditional conceptual foundations in theology. Proponents of moral progress and constitutional law may want to turn to secularized eschatologies in political theory, especially someone like John Dewey. But those have usually relied on democracy, the whoop and wharf of human experience and history, refracted through the formal political processes to try to identify what counts as moral progress and what doesn't count as moral progress. This was the justification, as I take it, of the views of folks like Brandeis and Frankfurter and other progressives who generally thought the court should defer to the political process, not sort of guide it with the imposition of its own understandings of the destiny of America. So the concern here is that appeals to evolving standards of justice and equality or liberty or the common good at this high a level of abstraction may be nothing more than just assertions of power on the part of the court, which brings me to the court in conclusion. When justices and sometimes the court enforce the notion of moral progress, right? The court within our American civil religion takes on a role of prophet, a role of priest, and a role of pedagogue. The prophet by discerning and declaring the evolving standards of justice, priest by mediating between the Constitution and the people, and pedagogue by teaching the people the way. I didn't realize I would be referring also to the Mandalorian there, but that's just a freebie. It may sound silly and even evidently preposterous to describe the court as prophet, priest, and pedagogue. But that is the implication, I think, of my claims about the incorporation of American civil religion into constitutional law. Some theorists of constitutionalism seem to appreciate this implication. So like Sandy Levinson has argued for what he calls a Protestant form of constitutional interpretation that emphasizes the people's interpretation of the Constitution, a bottom-up interpretation. Jack Balkin has argued for, again, recognizing this relationship between the civil religion and the court and constitutional law, argued for a more dialogic relationship, a dynamic relationship between the court and the people. But conceiving of the court as prophet, priest, and pedagogue, I think does put a fine point on what is at stake for our national life. And it bears further reflection from the fields of sociology, political theory, and constitutionalism. So thank you very much, and look forward to your questions.
As was said, I've been to Notre Dame before. I love coming to Notre Dame. The mores and assumptions about the world of this intensely Catholic place are frankly weird to me. But I find them admirable, and I like its strangeness. I particularly love talking about the issues that divide us. And it offers an opportunity to close what a character in Bernard Shaw called the gulf that separates class from class and soul from soul. I'm an agnostic secular Jew. I think that Jesus was just a guy. I don't believe in God, although but I've noticed that Christians seem to understand aspects of the human condition that secular liberals like me have trouble getting their minds around. It seems to me obviously the case as I read smart Christian writers. So I contemplate your traditions with enormous respect. And one reason why I like living in a liberal society, finally to come to the point, is that it lets me meet and even befriend people who are so different from me. I like doing the work of trying to understand them. My paper today is about recent Christian critiques of liberalism. I'm going to focus on Adrian Vermeulen and Patrick Deneen, who I don't think is here. I sent him my paper a week ago, so he knows what's coming. I think that they misunderstand liberalism. I find them ominously vague about what's going to replace it, really very much like earlier Christian flirtations with Marxism. In both cases, both distorted pictures of both the present and the future lead idealistic, admirable people to gullibly embrace authoritarian kleptocrats who don't give a damn about the people who the idealists want to help. I'm one of the liberals that they oppose. I have defended abortion, gay rights, drug use, and pornography, but I've also argued precisely as an inference from liberalism that religious people like them who reject all of those things ought to be able to live out their ideals unmolested by the state. For example, when they decline to facilitate same-sex weddings. I have a book on this you can easily find. I don't recognize myself in their claims that liberals aim to bully religious conservatives to the margins of society. There are some on the left who conceitedly do, but they aren't liberals. The enthusiasm on in factions on the left and the right for dismantling American political institutions, in my mind, calls attention to mind Roger Scruton's observation that we have collectively inherited good things that we must strive to keep, and that good things are easily destroyed but not easily created. Liberalism is one of those good things. So what is liberalism anyway? We're at the beginning of the conference, so it probably might be helpful to get that on the table. Deneen writes that liberalism aims at the greatest possible freedom from external constraints, including customary norms. And it's self-defeating, he says, because democracy requires extensive social forms that liberalism aims to deconstruct, particularly shared social practices and commitments that arise from thick community. But he says that liberalism can't help itself. Liberalism's internal logic leads inevitably to the evisceration of all institutions that were originally responsible for fostering human virtue: family, ennobling friendship, community, university, polity, church. And Vermeule similarly attributes a relentless aggression to liberalism, with constantly escalating demands, aiming to liberate the individual from all unchosen constraints. And this is the consequence of an inner necessity within liberalism. All of this talk of relentless logic and inner necessity promises that we're going to be given an account of the mechanism. And the language of historical inevitability I find reminiscent of Karl Marx, who developed a detailed, articulate account of the alleged inner logic of capitalism, in order to show that it would inevitably alienate and immiserate the working classes. Marx turned out to be wrong, but you can tell what his claims were. If you read Capital, there's lots of moving parts. You can see what the claims are. Deneen is clearer than Vermeule on this issue. He says that liberalism is most fundamentally constituted by a pair of deeper anthropological assumptions. First of all, anthropological individualism, the voluntarist conception of choice, and human separation from and opposition to nature. And these are unsustainable. It is not possible to impose constitutive social norms on a collection of autonomous individuals. It is not possible in a world of limits to provide endless material growth. And this is part of a long tradition of argument that liberalism tends to dissolve communities and alienate people. People have been arguing this since the French Revolution. But it's not clear how anthropological individualism can lead the state to attack communities. If people voluntarily form religious communities, my sense when I come to Notre Dame is nobody is here because the police put a bag over your head and dragged you here. People are voluntarily here. That's how a liberal society operates. The claim that liberalism is devoted to the conquest of nature, this is a more obscure claim within Deneen, I think misunderstands the relationship between humanity and nature. Humanity is constantly operating on nature. We've got a huge population. The population is, in fact, imposing severe ecological strain, preeminently with climate change. The only way in which we're going to address that problem is with the massive scientific research that Deneen is so suspicious of. It actually happens that lots of countries, I think about a third of the third world countries that have been advancing economically now do it with no increase in their carbon footprint at all, because there are technologies that we've developed here that have become available to them. The basic liberal practice of giving people the right to live as they like, and that's what liberalism fundamentally consists of. My own impression is that Notre Dame is different from a society in which the church has absolute authority, because everybody here who's here wants to be here. I think that that's better. Fundamental liberal view. So Edmund Fawcett has said that liberalism is fundamentally guided by broad ideas, acceptance that moral and material conflict can't be expunged, hostility to unchecked power, faith that social ills can be cured and human life can be made better. This is the aspect of progress that, as a liberal, I am devoted to. And respect for people's lives and projects, whatever they are. I think that Deneen and Vermeulen reject a number of these ideas. So do their progressive adversaries, who they think are the core of liberalism. They claim that I've made when I've tried to defend the Christian Baker against the state, is that liberalism fundamentally is about respecting the lives of people who don't share our moral aspirations. In a liberal society, people are free to break from customary norms. Some will and some won't. Deneen thinks that modern theory defines liberty as the greatest possible pursuit and satisfaction of the appetites. But actually, liberalism leaves everybody free to pursue that if they want to, and some people do, or something more exalted. So I think that and this is a long paper, and I'm barely scratching the surface here. The critique, I think, is based on a fundamental misunderstanding of liberalism. The Catholic thinker who I found better grasps the reality of what he's talking about, and who I rely on extensively in the paper, is Michael Novak, who understands that argues that a liberal society is better suited to the nature of man and the fact that people actually have free will than the kind of authoritarian regime that Deneen and especially Vermeulen admire. Other parts of the paper talk about misunderstandings in economics, in dynamics of American families, and American politics that largely drive the arguments that they are making. Boy, a lot of paper. What liberalism is devoted to is not an idea of the person who is free from all attachments and who's just an isolated monad in the world, but somebody who is capable of drawing a line between themselves and any identity they have, who understands that they are capable of separating themselves from whatever received role they have got. And I go back to Notre Dame professors, including some friends of mine who are in this room, one thing that has become clear in our conversations is they don't think the way that I think, but they know why they believe what they believe. And they can articulate why they believe what they believe. And they can give me a very hard time about what I believe. In our regime, they are free to reject their views and take on the sort of secularism that characterized my view. And the regime doesn't care whether they do or not. They are absolutely free to live as they like. The regime just demands that they do so on purpose in a regime in which they know the full range of their options. And that means that they know why they believe what they believe. This is a different, and I will suggest, a more reliable and more admirable basis for allegiance to Christian ideals or any ideals than ignorance and compulsion. Thank you.
Well, thank you all. I'm so glad to be here with you all. First time visiting Notre Dame. Really pleased to be here. Did the students in the room and others in the room get copies of the papers before today? No? Okay. So what I'll do is I'll condense about 45-page paper down into a few bullet points because I'll do this on the fly since I thought some of you may have received the paper. So Father Trostyanskiy and I, Father Sergey, have prepared a paper that tries to evaluate the compatibility of orthodoxy and liberalism. We're not intervening in recent Catholic debates over integralism. We think that those debates exist within their own premises. We're instead focused on trying to contribute something to the literature on orthodoxy and liberalism, which is an underexplored area, since Orthodox countries on the whole have not been traditionally influenced as deeply and as powerfully by liberal ideals as some of Western Europe and the United States. So I'm going to break down the paper into 4 different broad categories, though there's a lot more in it than what I'll discuss. So the first thing that we needed to do was to clarify what we mean by liberalism and orthodoxy. And that's an incredibly tough task because liberalism is itself a famously contested concept. We heard one version of it presented by Professor Koppelman, and there are other versions of it, many versions of it. It's tough to say what it is. Is it a theory? Is it a practice? Is it something to do with a historical form? It's quite tough. And then I'll talk about the ways in which orthodoxy and liberalism have different aims and different goals. And then I'll talk about what we think is the primary difference between orthodoxy and liberalism, which is over anthropological claims regarding human nature. And then finally, I'll talk about why we think these 2 traditions of thought are compatible. So we'll be arguing for compatibility, not radical incompatibility. So the first thing, okay, is what do we mean by liberalism? And our version of this is certainly going to be just one, but we think it captures something important about the liberal tradition. So we boil down liberalism to commitments to free exchange economically, representative government in some form, and that could include monarchy, and rights regime, equal rights regime, and more can be elaborated upon. And then we think that there are some foundational commitments to autonomy, to dignity, and to freedom that liberals tend to hold. So we heard just a moment ago, Professor Koppelman described liberalism as committed to free will. He said that implicitly, it's committed to that. So we think that's a central divide between orthodoxy and liberalism, insofar as orthodoxy would hold that, yes, the will is free, but in degrees, because there's enslavement to sin, there's enslavement to passion, so that the human being is not radically free metaphysically to initiate new causal chains and to sort of alter the fabric of being and to commence on some sort of journey that is defined purely by rational faculty. So that's one difference. Orthodoxy is not focused on eminent concerns like free exchange. It's not focused on equal rights as its primary focus. And it's not focused on representative government. It can support those things, but its primary aim is soteriological. It aims to redeem fallen humanity from the effects of sin and to unify human beings with God. So its basic task is soteriological. It seeks the unity of the human species with God. So very different aims. Now, this presents an immediate challenge. You have two traditions of thought, very different foci. How can we think of them in terms of compatibility when they're focused on very different things? And so what we talk about is that they are both orthodoxy and liberalism, visions of voluntary associations, intentional associations. So in the Orthodox case, we think about human beings voluntarily joining the church and then embarking on a quest for redemption, which through the life of the sacraments, membership in the church, they're shepherded along to. In the case of liberalism, we also think about a voluntary association. So Professor Koppelman just talked about the virtue of the fact that you're all here at Notre Dame voluntarily, right? So Orthodoxy shares this commitment to voluntary membership in the church, and in liberalism's case, the voluntary membership in theory, I guess, in societies, but that gets complicated. You know, there's this whole tradition of like how people actually become members of liberal states. So we think that there's some grounds to assess the compatibility of liberalism and orthodoxy to the extent that they both aim toward free association. And in fact, they both, in our view, have an eschatological vision in which people will be free and they will be dignified. So that liberalism has a commitment to this idea that people will exist in a society, dignified, free, with equal rights. Orthodoxy shares a vision of that kind, but it thinks that that society of equality, of dignity, of universal sort of remit to the rights of one another is really something to be obtained kind of at the end of time, at the end of the age. We can sort of make partial progress toward it now, but that the eschatological destination of the church, where people will be free, will be radically dignified, is going to exist really at the end of time, maybe in some super historical period where humanity is yet to be redeemed, but nonetheless exists at some different stage in human life. So we think there's a basis to compare the two in that regard. So they both aim towards the same things. Okay, and then this brings us to, well, they aim at this similar eschatological hope, but as I said, they have different foci, right? So the Orthodox Church focused on redemption, liberalism focused on eminent concerns. That for us is not a ground for radical incompatibility. It just means that we are deferring over application of liberal ideals. So for Orthodoxy, the aim or the hope or the vision of a universally dignified society where people exist free from arbitrary restraint or unjust restraint, and at the same time have equal rights, that for Orthodoxy can only be realized partially in this age. And so now I want to get into the anthropological divide that we think most separates Orthodoxy and liberalism. So for Orthodoxy, as I said, the mission is soteriological. And to think about that, you have to come back to the importance that the fall plays within the Christian tradition. So for Orthodoxy, we don't talk about this in the paper. The paper was quite limited in terms of like words, but we could only, I think it was like 10,000. What are we at now? 13 maybe? I'm not sure. So maybe we'll have the pair back already. So for Orthodoxy, the fall plays this incredible, like powerful, like paradigmatic role, right, in the terms in which the Orthodox mission is carried out. For Orthodoxy, we don't take the premise that human beings are guilty of original sin, but we have a similar approach insofar as we think that human beings are corrupted in their nature as a result of the fall. And because of the corruption that humanity has suffered, human beings are compromised ontologically. They're not able, in fact, to reliably act morally. They're not able to reliably act morally, in part because human reason itself has fallen. Human reason is darkened. So one of the first things that needed salvation when Christ was incarnate was the mind. So there was a debate a long time ago. I won't go into the details of it all, but there was a debate about, well, did Christ have a human mind? Well, the church decided, yes, he had a human mind. And one of the things that needed salvation was the human mind, the human faculty. So we don't assume as Orthodox that human beings are capable of rational action, perceiving what is needed in any situation apart from grace. So grace is an essential component of what it is to act morally with regard to the rational faculty. Now that presents another kind of challenge because for Orthodoxy, the process of salvation is one that occurs over time. So it's not as though, like in some Christian traditions, salvation is something that can occur pretty immediately, but then there are complexities there because the human being is usually in those traditions not being really internally transformed. They're instead kind of saved by some process of substitutionary atonement or something like this. In Orthodoxy, human beings are saved, but over time, and as a process of salvation, human nature is transformed. So we talk about a new creation. Well, I am almost out of time, and I will speed this up a bit. So for Orthodoxy, human beings are saved over a period of time. The process of salvation occurs along a continuum so that we are always morally compromised, even as we can improve morally, and our faculty of perception, our use of the nous can become clearer as we become more and more holy over time. The contrast there between liberalism and orthodoxy, and I think this is the main point, is that liberalism, for us, and how we have regarded it, does assume an incredible latitude of free will and capacity that orthodoxy denies. Now, there are different versions of liberalism, which we don't address in careful detail in the paper for reasons of space, but we think that virtually all versions of liberalism, even like the Rawlsian kind, where there's this notion that there's these burdens of judgment, and then in fact, people have to kind of constrain what they think about various things in the public realm. We think even that presumes that the human being is capable of exercising an appropriate degree of constraint, and also capable of identifying what should count in the construction of public reason and in conditions in which people are treated justly. So we think that versions of liberalism across the board attribute to human beings a radical freedom and a radical moral and rational capacity that orthodoxy denies because it says that human beings are ontologically compromised and therefore need salvation. Now, the very last thing, because I know I'm just about out of time, is orthodoxy is compatible in our view with liberalism, but it does hold right to the commitment that liberalism itself is incapable of fully realizing liberal ideals. So we have a long tradition of liberalism in American society and in many parts of Western Europe, and yet we have these enormous gaps between professed equality and lived equality. We think these gaps, particularly we can see them in American society as they've applied to things like racial justice, we think these gaps are just features of a fallen world, and so that you can't really hope that in a fallen world where people are always in the process of making a recovery toward moral capacity, that we will be able to achieve the kind of, in our view, liberal kind of utopian vision that liberalism, while it does, I think, as Professor Koppelman has said, it does kind of say, well, people are just sort of free to choose their own vision of the good. We think even that vision, where people are free to choose their own vision of the good, is always going to be impacted, restrained, and undermined by existing political conditions and existing cultural life. And we think orthodoxy has a better explanation as to why human beings are always kind of like ensconced, always kind of like weighed down, kind of muddied up by the effects of the fall. So that's our basic view. We also have a section at the very end of the paper on how orthodoxy would approach the separation between church and state. And we think that the traditional view of symphonia, which is this unitive action where the church and the state are cooperating, reflects this idea that orthodoxy and liberalism can complete one another. So that orthodoxy and Christianity, as it seeks to redeem humanity, as it seeks to administer the sacraments, as it seeks to bring a relatively small number of holy people to greater union with God, can then help to shepherd society and humanity in the direction that liberalism tends to uphold with regard to equal rights, representative government, and free exchange. So I will have to wrap it up there because I'm out of time. I look forward to your questions, and please do read, the full version of the paper once it's out, because it's just like a very, very small snippet of what we argued. Thank you.
Well, thank you very much, all of you. And what Professor Paradise said at the end applies to all three of the papers. There's so much more in them, but we can explore a little bit more now in some time for questions. Before we turn to the audience, I thought I'd just invite the panelists to engage one another if there's questions or comments directed at the other presentations and papers. So, Andy, please.
So I think I want to say, well, first of all, the belief in progress, it can be a belief in eschatology. This was a theme in both of the other two papers. It is not necessarily the case when my engine is malfunctioning and the oil mechanic repairs it. The mechanic does not believe either that he is accelerating the end of days or that he is going to build a car that is going to last forever. He just thinks that he's going to make things better. And the commitment to progress that's in the Constitution, it's there in the original Constitution. You look at Federalist number 1, it begins by saying, big question is, can human beings take control of their political destiny? Are we always subject to random accident and misfortune? And so the idea, writing a Constitution and being governed by it already involves an idea of progress. And then there's the detail of slavery. The Civil War amendments are based on the idea that it's just unrealized liberal ideal here. I'm afraid I don't recognize myself in the claim of Brandon and Father Sergey that liberalism constantly ignores how far short liberalism is in practice from its own theoretical vision of human life. My experience is that liberals can't talk about anything else. The whole point, the core liberal activity is not Dr. Pangloss telling us that we're all it's for the best and the best of all possible worlds, but that here are all of the ways in which things are defective. If the 13th and 14th Amendments are judicially enforceable, that means that the judiciary has a role in bringing about the progress that liberals contemplate. We don't think that society is already there. The basic claim is that where we are now is bad. And so glaring failures of liberalism in practice are exactly what liberals are complaining about. We do nothing but complain.
Can I just respond to that?
Please,
So,
of
I mean,
course.
what's interesting there, right, is I think, maybe you can help resolve this. I think there might be a degree of ambiguity in the claim, because on the one hand, it's, well, liberalism sort of needs to do what they like.
Mhm.
We're not actually like
Yep.
foisting any kind of vision to
Yep.
do it on anybody. On the other hand, there's this idea that, well, really, we're always complaining about things, but there's always complaints, but there's no kind of central organizing framework with regard to the prior view that people are left free to do what they want with regard to how any of those claims should be resolved. Which means, right, that liberalism might very well have a lot of complainers, but doesn't have any like real self-examining central organizing category by which we can think about the ways in which we resolve the various problems that plague the liberal tradition. So you think about something like slavery and court enforcement. One of the central reasons that critical race theory arises as a movement is because of liberal discourse's failure, in its view, to really think about the ways in which colorblind jurisprudence fails to deal with the facts on the ground of racial subordination in American society. And now you have, I think, as you put in your paper, more progressive radical claims that you would differentiate from liberalism that are really offering fixed substantive visions of how we ought to move forward. But you want to distance yourself from that. You want to say, well, that's not really liberalism, right? So that's the challenge I have. It seems to me that yes, there is this constant room for complaint, but there's no kind of commitment within liberalism itself that gives you a ground to say, okay, why is it that we don't make progress on these things? Because it's just kind of left as a free for all, it seems.
It seems to me slavery is an issue we made a lot of progress on.
By constitutional amendment.
So I appreciate your tacit acknowledgement that the U.S. constitutionalism incorporates some Christian eschatology. So I want to have a question for your paper, which is, I'm concerned that your response to Denis ignores the vast majority of people who are operating under the flag of liberalism in our society. So to focus strictly on cases in which there are rights in conflict. Most left liberals, to say nothing of progressives, systematically favor and believe the government ought to favor progressive rights claims over traditionalist right claims when they're in conflict. In some ways, you're a sort of a unique person to respond to because you're one of the unique left liberals to stake out a slightly different position than that. But that you don't fit the mold doesn't mean that he's arguing against a straw man. He has a wide and robust group that he's aimed at. That has nothing to do with your criticisms of what comes next and what a muscular Christianity and is it like in the law or something like that. So do you have any? What's your response to that?
So I think that I certainly will agree with the progressive left or with the more extreme critical race theorists about evils in the world. On the same way that pre-revolutionary Russia, I'm not a fan of the Tsar. The difference is that then the folks on the far left will say, given the Tsar, the best solution is Lenin. And I'm going to say, no, Lenin is going to lead to a deep betrayal of the working class, even worse oppression than they had before. So this is the wrong solution to the problem. We agree about the problem. And on the progressive left, actually the progressive left, the liberal left, I cite some data in the paper, they're about 12% of Democratic voters. They're a larger proportion of young college-educated professionals. They live in large metropolitan areas. They tend to work in the media advocacy groups and the Democratic Party infrastructure. They have power out of proportion to their numbers. But I do not think that this is an irresistible force.
So just to be clear, I feel like your response to Denis is one about labels, because you would say, well, I'm a liberal and I don't believe those things. And all these other people who claim to be liberals aren't.
And I define liberal and I explain why those folks are not us.
And they're going to define it differently. Right. I mean, there's no judge but God to determine what a real liberal is, to go back to steal a page from Locke.
Deneen makes clear that Locke is the enemy. That the idea that people ought to be free to live as they like is inevitably going to lead to social disintegration. So he clearly is opposed to the kind of liberalism that I espouse. He thinks that the kind of liberalism that I espouse is inevitably going to lead to the kinds of repressive results that he fears. So then we can argue about the logic.
Great. Let's turn it over to you, Professor Smith, please.
I don't want to jump into this point, because I don't think we should let Andy out.
No, don't do that.
So the way you presented the book here is kind of a live and let live, lions and lambs, all, do their own thing and can get along well. And on the religious side, we have the integralists who are trying to impose their view. And on the left, we have secular left, we have progressives who are trying to impose their view. But the liberal solution would just be to try to preserve everybody's ability to live in accordance with their own beliefs and values. And you gave a specific instance. You say people like you who have defended the Christian baker, against discrimination. So I have to say that came as a surprise to me, because you and I have had lots of conversations. And I remember a debate we had at Ohio State 3 or 4 years ago, where I was defending the Christian baker, and you were very much on the other side. The baker should, it should be subject to suit. There should be no free exercise exemptions. Now, in your book, I think you have tried to say we could make some room for the baker by allowing people like Christian Baker to announce to the world, make it public, that they're Christian and they don't believe in, making a wedding cake for a same-sex marriage, but they still have to do it if someone asks them to, or be subject to suit.
No, that's not. I did not say that.
It's just that they're going to get sued over and over again if they. But the more general point is just that this sort of live and let live thing, obviously, is much more difficult to practice. It's not so easy to do. And I think you should acknowledge more that even liberals like yourself, who are trying, and I respect that you're sincerely trying to find room, are still going to draw the lines in ways that you might think, are leaving room for everybody to live the way they want. But the other side is going to think, no, you were marginalizing me, you're pushing me out of society, you're pushing me out of people. You don't seem to acknowledge that.
Yeah, no, I mean, it's true that, the fact that there are same-sex couples who are, living unmolested, they're married, they have full legal rights, and, they've got children, they have a dog. Deneen regards that as a kind of personal insult. And there's just nothing that you can do about that. And, for liberal society, there are some people who are going to regard the fact that other people are living their lives unmolested in their appalling ways is a kind of personal insult. I can't do anything about that. I want the baker to be able to carry on his business according to his ideals. I want gay people to be able to live out their ideals. And I think that when we debated, I resisted some of the constitutional claims that the baker is making. But I want to figure out a way to accommodate him. I'm not married to what I did in the book. I've endorsed the Fairness for All legislation in Congress, which uses a different method for drawing the line. But the basic liberal impulse is to try to see if there is a way to accommodate everybody.
I think it's only right for me to say at this point, because Professor Deneen has been invoked in absentia multiple times, that he was invited and was not able to attend this symposium. So this is not Steve and I don't see ourselves as like proxies for him. None of that. We wish he were able to join us, but he wasn't able to.
Great, thank you. Other questions, comments, responses, inquiries?
This maybe runs through several of the papers, but I think especially to Andy's point that there's a kind of question that keeps going in my head about these people who are choosing to become members of communities and form different types of communities. But where do they come from? Like what's the kind of that we don't just kind of emerge fully formed and autonomous in making our choices. And the way in which education, especially that takes on significance. Something in a case like Wisconsin versus Yoder, whose anniversary we're coming up on, I don't know if things is rightly decided or not, but it seems to me that whatever the kind of constitutional holding, a kind of deep commitment to the ability of communities to inform citizens for traditional community over and against efforts on the part of the state or the progressive left, whatever, to undermine that ability it has to be kind of central to your project.
Yeah. So, in general, where do people come from? We know where you all know where babies come from, right? They get born, they get raised in families. The families, and I'm very sympathetic to Melissa Moschella's paper later today that argues that we got to give papers families a lot of leeway. On the other hand, there is a liberal conception of child abuse, so that if which Yoder is right on the margin of. Clearly, if a parent thinks that a child will be holier if the child does not learn how to read and write, because reading and writing is going to corrupt them, from a liberal perspective, that counts as child abuse, even though the child is not being physically harmed in any way. We demand that people have certain capacities as citizens, and if you raise a child that deprives the child of those capacities, then the liberal state is going to get tough and intervene.
All right, thank you. I see that Professor Billingham has his virtual hands raised. Can we get him on the screen? Perfect. Yeah, Paul, the floor is yours.
Thanks a lot. So I guess I wanted to ask a question about the kind of eschatology stuff, Nathan. So as you can tell from my accent, I know nothing about the American Constitution. So I'm going to assume everything you've said is true. But I guess I just have a question of, if you have an evaluation of this, a normative evaluation and a Christian evaluation. So is this a good thing for eschatology to be built into a constitution of a state, or is that itself unchristian? It strikes me that seeing a state or a society as the city on a hill, when Jesus said that to his disciples, not to a state or society, might itself be something Christians should be worried about. So my question is this a way that actually that American constitutional liberalism has gone wrong from a Christian perspective? And that kind of connects to the final paper, right, which is about how liberalism and Christianity have different eschatologies, and maybe throwing them in together might be a mistake. So yeah, I guess I just wonder if we should, if you're right, whether Christians should celebrate this or actually be concerned about it because it's putting eschatology in the wrong place.
So I think if it were overtly eschatology and overtly theistic, it would be more cause for concern. As it is, it's so diluted and watered down. I think it's in some respects serving as a make weight with respect to reasoning about, how the Constitution should be interpreted. Christians disagree a lot about eschatology, and especially American Christians. It has become a really interesting feature of our religious history and life, especially Protestant American Christians. And so incorporating any highly contested notion of it into constitutional law is, in that regard, a bad move from the standpoint of liberalism, certainly. Even if you don't hold a strict view of public reason and things like that, it leads to disagreement and strife. So it's difficult to say what the right Christian answer is in the abstract, because I think Christians have had very different views about this in times and places. The Puritans certainly thought it was right to incorporate notions of eschatology into their corporate governance and their religious life, both. I will say this, though, Paul, as a matter of my interest in it theologically, is more along the lines of the way that Oliver O'Donovan thinks about all government judgment being and I'm going to butcher perhaps his precise language here, but something like a secondary theater of God's judgment, in the sense that it is reflecting sort of the human duty and calling to anticipate ultimate judgment. And I think there's a lot to be worked out within O'Donovan's own thought in that regard. What it means for American constitutionalism is that uniquely, in a way that it is not the case in the UK or has not been historically, and I
pray for your sake that it remains so, because I don't like judicial supremacy generally. It is uniquely the case in the US that the United States Supreme Court is increasingly the secondary theater of God's judgment in American life, which is troubling if you care about things like freedom, equality, democracy, fairness, because it delegates to a quorum of 5 the authority to make decisions about right judgment. And I've obviously revealed a bit of my own jurisprudential philosophy, but I think these things are bound up for me.
Andy, please feel free.
Yeah, so I do think that there is a pathology associated in American political culture with the eschatological vision, because it has sometimes been taken to mean that whatever America does is good because it's us that's doing it. And I thought that was manifestly the case, justifying torture under Bush. It used to be something that Nazis did. Now it turns out that it's the patriotic thing to do. And today, there is a hostility in teaching about history of racism and slavery in the schools because it makes America look bad. And America, that can't possibly be true because we are always the source of goodness. So this is another way in which liberalism constantly harps on the gap between liberalism and the theoretical vision of life. I think liberals will say the US is potentially a power that can bring liberalism to the world, actually has done to a large extent after World War II. But the eschatological vision has got these dangers, which are very much with us.
Yeah, if I can follow up on that briefly. Yeah, so this is a place where American civil religion is in tension. There are tensions within it, and it's contested. I read things like the 1619 Project and white Christian nationalist responses to that, and lots of intermediary positions as all being, in some respects, fights over American civil religion, about the origins. So what is the original sin? How can redemption occur? What is the telos, or the end goal? And there is certainly a strain, and it tends to, this is where American religious history with respect to what sociologists would call like particular or specific religions, that is the sort of actual churches, I think fuels these different views, because the sort of premillennialism of a more fundamentalist, right-leaning evangelical movement beginning in the early 20th century tends to support more of the Christian nationalism. And that gets translated into whatever America does is what God is intending to do in the world, because by virtue of its destiny, America is God's sort of instrument. There's a pretty good book by a guy named Philip Gorski at Yale, who has tried to make the normative case for what he calls prophetic republicanism as the sort of the best version of American civil religion, and he distinguishes nationalism on one hand, and I think he calls it radical secularism on the other, both of which he acknowledges to be different veins or different sub-traditions within American civil religion, but argues they shouldn't have as much claim to our allegiance.
Great. Brandon, Sergey, would you like to weigh in any way on this exchange before we bring it to a close?
Well, I mean, I had hope that you will never ask that question. I'll keep silent and I'll look smarter. But yeah, unfortunately, I'm a stranger in this caucus. I have no legal background, so I can't engage fully in this very deep and fascinating conversation. But I would just say that I'm so glad that both Nathan and Brandon brought up this subject of eschatology, because I think it's something that is deeply ingrained in sort of like this human nature, because we are so aspired to feel things in their kind of fullness and completeness. And eschaton is that which supervenes upon any of your action and kind of manifests its completeness and perfection and fullness, and which we don't really feel in real life, which is always compromised. Yes, and as far as liberalism is concerned, we can see multiple failures to deliver its promise, right? And it's always kind of in some ways disappointing, but this eschatological kind of aspiration to that end, which is fully fulfilled. I mean, we normally experience it liturgically, right? When we are kind of no longer in this linear sort of procession of time, but time becomes erotic, kind of, right? Allows us to see things in its fullness and completeness. And I think it's necessary for any legal court decisions or political decision-making process to have that eschaton, yes, in France, so that nothing is absolutely compromised, but there's something truly ideal and full and perfected that sort of offers a guideline and becomes the ultimate judge and interpreter of any court decision. I think there's something good about it. I thoroughly enjoyed Andrew, your paper was absolutely awesome, and Nathan, thank you so much. Brandon's paper is superb, so I just would like to praise you all and express my gratitude and appreciation. Amy, thank you so much for inviting me, but I can't really say much substantively, kind of, give you any comments. Thank you so much.
Thank you, Sergey. Well, that's a wonderful point on which to go and experience the dissatisfaction of our desire for fulfillment in the form of a 10-minute break. But before doing so, please thank our panelists.
What do I know about?
No, well, I was.
I mean, probably starting. Give it a moment. Okay, we're back. So good morning, everyone. I'm Stephan McDaniel. I'm a visiting assistant professor here at Notre Dame Law School, and also the inaugural Rhodes Fellow in the Church, State, and Society program, which one of our panelists Rick Garnett runs. So he's my boss, so I will say only the best things about him. I hope you'll agree that we really couldn't hope to get a better panel to discuss the issues before us today. Christianity's response to liberalism. I suppose we could get Jesus, but that was not practical. So the panelists are highly distinguished academics, far too distinguished for comfort to introduce them. It's quite burdensome. There's too much to say. So I'm going to leave out a lot of impressive credentials and achievements. But I'll begin with Professor Brady. Kathleen Brady is an affiliated fellow at the Center for the Study of Law and Religion at Emory University. She has held faculty appointments at Villanova University, University of Richmond Law School. Her publications have appeared in numerous law reviews, and her book, The Distinctiveness of Religion in American Law, Rethinking Religion Clause Jurisprudence, was the recipient of a book award from the Catholic Press Association in 2016. Professor Brady's scholarship focuses on the intersection of law and religion, including the First Amendment religion clauses, religion in public life, law and theology, and Catholic social thought. Her publications have appeared in numerous law reviews. She holds a Bachelor of Arts from Yale College, a Master of Arts in Religion from Yale Divinity School, and a Juris Doctor from Yale Law School. Professor Richard Garnett is the Paul J. Sherrill Fort Howard Corporation Professor of Law at Notre Dame, and a concurrent professor of political science. And as I mentioned before, the director of the program on church, state, and society. Professor Garnett teaches and writes about the freedoms of speech, association, and religion, and constitutional law more generally. He's a leading authority on questions and debates regarding the role of religious believers and beliefs in politics and society, and has published widely on these matters. He earned his JD from the Yale Law School in 1995, back when Mark Wahlberg was Marky Mark, and his BA was summa cum laude from Duke University in 1990. He joined the faculty in 1999 after practicing law in Washington, D.C. Finally, Professor Stephen Smith is the Warren Distinguished Professor of Law at the University of San Diego Law School, co-executive director of the Institute for Law and Religion, co-executive director of the Institute for Law and Philosophy. His areas of expertise include constitutional interpretation, torts, jurisprudence and legal theory, law and religion, religious freedom, separation of church and state, federal courts, and constitutional law. Professor Smith was the Robert and Marion Short Professor of Law here at Notre Dame and was the Byron White Professor of Law at the University of Colorado School of Law. In 2020 to 2021, Smith was named the Herzog Endowed Scholar. His recent work includes the book Fictions, Lies, and the Authority of Law from Notre Dame Press, and New Old Foundations for Religious Freedom, published in the Journal of Law and Religion. With that, I'll turn it over to Professor Brady for her remarks. Sorry.
Hi. At first, I have to thank very much for that wonderful introduction. I have to cut myself down at least half, maybe 3/4 to meet expectations. But in any event, thank you all for being here. For as long as there's been liberal political thought, there have been criticisms of liberalism. But in recent years, new criticisms from within conservative Christianity have quickly accelerated and taken new directions, as they've also spilled over from the world of ideas into the rough and tumble of American politics. In my time, I'm going to give an overview of some of my analysis of these critiques, including where I think they hit the mark, where I think they go deeply wrong, and also where they nevertheless help to set up new possibilities for revitalizing the liberal tradition. First, what are some of these critiques? While different writers emphasize some to a greater degree than others, a consistent set of complaints has emerged. Liberalism, it said, undermines human flourishing when it elevates human autonomy to the highest of human values, stripping human beings of their constitutive, social, moral, and spiritual norms, undermining communities and religious institutions, and subjecting individuals and groups to social and economic forces that operate without any ethical meaning and direction. This complaint is primarily a criticism of what has become known as comprehensive liberalism. Comprehensive liberalism understands human autonomy as a central, if not the central, element of human flourishing. Political liberalism, named by its first and most prominent opponent, John Rawls, envisions liberalism differently. It calls for a political society of free and equal citizens who, while possessing very different understandings of comprehensive moral views about the good, agree to live together according to principles and rules that they can all be expected to agree upon. Central to political liberalism is the idea of public reason, a moral requirement that political discourse and decision-making be governed by shared liberal principles, as well as generally accepted forms of reasoning and common sense. Political liberalism has been criticized for envisioning a form of politics that is empty of human ideas of good and flourishing. So while comprehensive liberalism misunderstands human flourishing, the problem with political liberalism is that it eschews comprehensive views of the good altogether. And to these critiques are added many more. For example, liberalism claims to be neutral, but it's not. Comprehensive liberalism is plainly not neutral. It elevates human autonomy over religious visions of the good that see human flourishing as something as part of a relationship with God and conformity to divine direction for human life. Political liberalism is also not neutral. It claims to describe a fair system of social cooperation for free and equal citizens, but excludes those who won't play by the rules of public reason, calling them unreasonable, and then sanctioning their suppression in order to protect liberal values. Complaints about liberalism's destructiveness go further to the erosion of religious freedom. Liberalism's demands override religious claims when they come into conflict, and its fights over religious freedom increasingly pit religious claims viewed in traditional understandings of morality, family, and human sexuality against claims of equality. Expanding understandings of equal citizenship threaten religious ways of life and communities. So, what about these critiques? How strong are they? In many respects, they attack caricatured versions of liberalism, or at least versions of liberalism that don't represent all possibilities of either the comprehensive or political strains of liberal thought. So, for example, comprehensive liberalism certainly sees human autonomy as a central human value, but it doesn't necessarily see it as the only human value or exclude other values. Humans exercising freedom can choose to embrace religious ways of life or any other form of human flourishing, and liberalism protects them when they make these different choices. Comprehensive liberalism also doesn't exclude the possibilities that communities and institutions play a role in facilitating the exercise of human freedom, and comprehensive liberalism contains within it some room for protecting these communities as well. For its part, political liberalism doesn't envision an empty politics. The shared political values that inform public reason represent an overlapping consensus that's supported by citizens for many different reasons, and religious citizens will naturally ground these commitments in their religious comprehensive understandings of the good. So in this way, religious ideas are not absent from liberal politics, but they come in indirectly to the extent that they help to ground shared political values. Moreover, the requirement for public reason doesn't need to be understood in a way that excludes all forms of religious reasoning in public debate and public decision-making. In fact, it can be understood in a way that allows religious reasoning to come in quite often. In addition, both political and comprehensive forms of liberalism include some versions that have been referred to as perfectionist versions of liberalism. And in these versions, states can promote controversial understandings of the good as long as they don't use coercion. And of course, the categories of comprehensive and political liberalism don't exhaust all possibilities of how liberalism is understood. While these are the dominant theories in the academy, in practice, American law selects some rights and demands for equality to prioritize, and then leaves plenty of room for citizens to debate and pursue the good in politics. Religious liberty is, of course, one of these rights. Some of liberalism's defenders have embraced demanding understandings of equal citizenship in culture war contexts that have tended to weaken religious liberty outside of private settings. But others have called for better balances of the shared values of liberty, equality, and freedom. So, is that all there is to say? Today's new Christian critiques of liberalism raise some valid concerns, but they're not fatal in the way that liberalism's detractors think. Liberalism may need some corrections, but it has within all its major strands the resources for its cures. I think there is both more to say and more that needs to be said. Regardless of their merit, tweaks to existing theories of liberalism are unlikely to change the minds of liberalism's harshest critics. As Adrian Vermeule has written, he's not interested in the latest minor paper on Rawlsianism. This is in part because he's most interested in lived rather than theoretical liberalism, but it's also because he and many other critics have something very different in mind. What they have in mind is something that I will call integration, a term which is reflected in the name that Professor Remuel and other Catholic integralists have adopted themselves. Behind many of today's conservative Christian critiques of liberalism is a longing for a vision of politics that's integrated with religious principles and reflects the priority of God in all aspects of human life. For Catholic integralists in particular, this means that the state should not be neutral about the good, and it should not just promote robust private rights to pursue religious visions of human flourishing. The state must promote the common good, understood as something greater than any private good, and as something that's oriented ultimately to the highest of all human goods, life with God. Comprehensive versions of liberalism that elevate the value of human autonomy will make no headway with those adopting this view. And for its part, political liberalism stumbles right out of the gate when it assumes an overlapping consensus in favor of liberal values. In fact, this overlapping consensus is breaking up. So is this then all that can be said? Critiques of liberalism that seek the integration of political and religious values are simply incompatible with liberalism, and we're left with two opposing visions for human or for political life vying for power. I don't think so. The desire for an integrated vision of religion and politics is not surprising, and in fact, it's nothing new. At the heart of religious belief and practice is a relationship between human persons and the divine ground or source of all that is, and the demands of this relationship naturally reach out into all aspects of human life and assume a priority over all other human concerns. Indeed, Rawls himself recognized this when he understood that the citizens' comprehensive beliefs systems have to support liberal values for liberal societies to be stable. So what makes the difference is what integration looks like. And at this point, I'll turn to Catholic integralism, which includes some of today's strongest critics of liberalism and also the most developed alternatives to alternatives in the form of a post-liberal society. For many Catholic integralists, talk of personal rights and liberties is replaced with talk of a greater common good that exceeds and indeed subsumes personal goods. Talk of democracy is replaced with talk of hierarchy and authority. Talk of self-government is replaced with talk of rulers and subjects. Talk of persuasion and voluntarism is replaced with talk of coercion. But this is where Catholic integralism is most deeply flawed. Catholic integralism is wrong about current Catholic social teaching, and it misses the Church's most important insights about human nature and social and political relations. In fact, the Church places the human person at the center of politics and embraces a rich understanding of human freedom that grounds human rights in the human person's possession of reason and free will, and their desire and duty to seek the truth and follow it as they come to know it. Political authorities exist to promote the common good, understood not as a good that exceeds and subsumes the individual, but as a good that comprises the social conditions necessary for the fulfillment of all persons in their individual and social lives. The common good includes material conditions necessary for a life worthy of human dignity, as well as conditions that facilitate but don't direct the religious life of citizens. Religious liberty and other human rights are essential components of the common good. Democratic self-government is favored because it allows for the participation of all citizens in the exercise of responsible freedom. The Church is involved in the social and political spheres, but not as a ruler. Rather, the Church operates as citizen and teacher, speaking to Catholics as well as all people of goodwill about moral and spiritual values and entering into dialogue with them. This is, of course, a version of liberalism, but it's not a comprehensive liberalism that decouples liberty from truth and the duty to seek it. It's also not a political liberalism that assumes a set of liberal values without seeking to justify them in light of comprehensive claims about human nature and ends. It's also not a static version of liberalism. The church recognizes that her social teaching develops over time as she extends enduring principles to meet new challenges and conditions. Political liberals in particular have tended to be agnostic about the justifications for liberal values. To defend these values would take them into debates about comprehensive visions of the good, and they have wanted to avoid these debates. However, the emergence of today's conservative Christian critiques and their spillover from the world of ideas into the world of real politics makes entering this terrain essential. Once it's entered, one will discover a number of different versions of liberalism and a dynamic process of development that involves thinking and rethinking liberalism's foundations and content. And Catholic social thought is an important voice in this dialogue. It draws on many influences, including America's own political traditions, and it offers an especially rich understanding of human freedom that can inform an understanding of politics that is not morally and spiritually empty, but rather free and full. Liberalism, like the church's own thought about politics, is a tradition. And as a tradition, it's strengthened and renewed when it reflects upon and develops its own foundations and content over time. Catholic integralism isn't wrong about the need for harmonizing religion and politics, but it's wrong about what the church has to say about this harmony. But Catholic integralism's flaws have an important benefit. They invite consideration of what the church does say about politics and what it does have to offer to those inside and outside the church.
Well, thanks so much. I want to say thank you in particular to all the students on the law review. You guys have done so much work this month. Those of you who aren't students here might not be aware, but this is actually the second pretty major symposium that these students have put together in the space of 1 month. So those of us on the faculty and in the Notre Dame community have been shamelessly freeloading on their hard work, and we're very grateful. So the theme of this symposium, as we all know by now, is liberalism, Christianity, and constitutionalism. That covers a lot of ground. And I want to start with a possibly provocative claim, and that is that liberalism and constitutionalism, correctly understood, need Christianity. And when I say that, I don't mean that they need Christianity in the sense that all creation stands in need of the redemption and saving action of Jesus Christ. I mean instead that Christianity has resources within its political theology that liberalism and constitutionalism need. I want to say a few caveats just to avoid the charge of chauvinism here by the fact that I'm invoking Christianity. Obviously, it's one of the themes of the symposium, which I invoke in my defense. It's also the theology that the political theology that I know best. I feel confident, but I'm not trained enough to say that some of the features of Christian political theology that I think liberalism and constitutionalism need are present in other religious traditions as well. Okay, so what exactly are we talking about? I think there's no point in trying to define definitively liberalism here. We've heard some suggested definitions or the characteristics of it. It's been said that liberalism is a political doctrine that takes protecting and enhancing the freedom of the individual to be the central problem of politics. It's been said that liberalism is a political and moral philosophy based on the rights of the individual, liberty, consent of the governed, political equality. It's been said that liberalism is an ideology committed to the individual and a society in which individuals can pursue and realize their interests. And it's been said that liberalism is a philosophy that starts from the premise that political authority must be justified. So clearly, as we've heard, liberalism comes in a wide variety of shades and flavors. Scholars disagree, indeed, liberal scholars disagree about its foundations, its premises, its content, and its implications. This variation complicates, it seems to me, some of the recent efforts to explain, in Patrick Deneen's words, why liberalism failed, or to develop proposals for post-liberalism. Liberalism comes in more or less comprehensive varieties. It can be thicker or thinner. It can be more or less perfectionist, as we've heard. It can be more or less pluralist. It has left and right varieties, and it can cash out policy-wise in a range of ways. But I think we can say that conversations about liberalism will generally encompass the rule of law, private ordering, reasonably regulated market economies, free trade and movement, some skepticism about legal moralism, and so on. The specifics can and do vary. Now, the philosopher William Galston, from whom I've learned a lot, has argued that the liberal tradition contains two distinct strands of thought, one emphasizing a principle of autonomy, while the other stressing a principle of diversity or pluralism. And these principles, he has suggested, can sometimes be in tension with each other, and I'll say more about that. One strand might tend to de-emphasize and even to dissolve the ties between persons and authority-carrying associations, especially those associations that are unchosen, such as family. While the other strain of liberalism, quite the opposite, might focus precisely on creating and protecting space for these associations, these mediating institutions to flourish. In any event, for present purposes, I want to suggest that liberalism is best understood as encompassing commitments to both liberty and limits. More precisely, liberalism aims at liberty, perhaps hence the name, but it achieves it, to the extent it does, perhaps paradoxically, through limits. So hold that thought. What about constitutionalism? What's that? Here comes a ridiculously quick and dirty and superficial answer. Constitutionalism, as I see it, is the enterprise of protecting human freedom and promoting the common good by categorizing, separating, structuring, and limiting power in entrenched and enforceable ways. Now, for some, but certainly not all, it's essential to this enterprise that it happens to be done through writing. Walton Hamilton, for example, said more than 75 years ago that constitutionalism is the name given to the trust which people repose in the power of words to keep a government in order. But putting that aside, the historian Charles McElwain was more succinct. Constitutionalism, he said, has one essential quality. It is a legal limitation on government. Yet another feature of constitutionalism, perhaps the essential one, is that the enterprise is animated by an appreciation for the fact that the authority of government, which again is limited legally by the Constitution, is not the only authority at work in human society and affairs. As the great legal historian Harold Berman put it, perhaps the most distinctive characteristic of the Western legal tradition is the coexistence and competition within the same community of diverse jurisdictions and diverse legal systems. It is, he said, this plurality of jurisdictions and legal systems that makes the supremacy of law possible. This pluralism, Berman thought, has nurtured legal, political, and economic growth. It both reflects and protects political and other freedoms. In a similar vein, great English legal historians like Maitland and Maine, they appreciated the fact that distinctions and competitions among plural authorities have been and remain crucial to constitutionalism's success. And so a regime that concentrates authority in any one place, the state, the church, the market, the mob, and suppresses it elsewhere is, I think, not an authentically constitutional regime. So to say with the Jacobins that there can be no rights except the right of the state, and that there can be no other authority than the authority of the republic, is to reject constitutionalism. Rousseau's assertion that a democratic society should be one in which nothing stands between man and the state, like his contention that non-state authorities and associations should be proscribed, was deeply anti-constitutional. Now, the Constitution of the United States, on the other hand, for all of its flaws and foibles, seems to me to be a shining example of constitutionalism as these thinkers have described it. As I hope every law student learns, those who designed and ratified the Constitution, they understood and embraced the idea that political liberties are best served through competition and cooperation among plural authorities and jurisdictions. and through structures and mechanisms that grant, arrange, structure, check, diffuse, divide, and limit political power. Our Constitution, then, is more than a litany of prohibitions or a catalog of rights. Our Constitution is, in the end, the law governing the structure of and the allocation of authority among the various institutions of government and preserving the sphere of non-state authorities to operate within their appropriate domain. So our Constitution, our constitutional experiment, if you want, reflects the belief that the structure of government matters to the good of human persons. As the late Chief Justice William Rehnquist once put it, the constitutionally mandated division of authority was adopted precisely to ensure protection of our fundamental liberties. Justice O'Connor, in a similar vein, said that the separation of powers was designed to implement the fundamental insight that concentration of power in the hands of a single branch or in the hands of a single government is a threat to liberty. We could go on, of course, collecting quotes and gathering observations by Madison and Montesquieu and Tocqueville, but there's no need to belabor even a point as fundamental as this one. The genius of the American Constitution, that is, of American constitutionalism, lies in its use of structural devices to preserve individual liberty by limiting power. So, like liberalism, then, constitutionalism can be seen as promising liberty through limits. So what does Christianity have to do with it, besides everything? Again, the suggestion so far is that liberalism and constitutionalism, or perhaps liberal constitutionalism, they rely for their success, both in theory and in fact, not only on these structural features like separation of powers, but also on the existence and the health of authorities and associations that are outside and independent of the state. And I've tried to argue elsewhere, as have some other of my colleagues up here, that our tradition of constitutionalism was made possible by, and might still depend today on, the independence of the church from secular control. An independence that I think it's fair to say Christianity first proposed and insisted upon. The distinction, as Pope Emeritus Benedict XVI put it, quoting Matthew's gospel, between what belongs to Caesar and what belongs to God is fundamental to Christianity. As Pope Gelasius said to Emperor Anastasius, and my law professor friends here know that I love to milk this quote, more than 1,500 years ago, two there are, not one, by which this world is ruled. It is this core tenet of Christian political theology, the differentiation between religious and political authority, along with the freedom of the church and the limits on the state, on which it seems to me liberalism and constitutionalism crucially depend. And this differentiation, again, as the Pope Emeritus put it, came into the world first through Christianity. Until then, he observed, the political constitution and religion were always united. It was the norm in all cultures for the state to have sacredness in itself and to be the supreme protector of the sacred. But Christianity blew this up, and it deprived the state of its sacral nature. And this is a fact that I think, as Kathleen pointed out, has implications for the debate about interrealism. Now, to be sure, these are highly abstract thoughts, and I'll try to put more specificity into them in the final paper. I've tried in other writing to connect these abstract thoughts to American thinking and to American understanding and to judicial doctrines about the idea of church-state separation. I have argued that correctly understood, and to be sure, it isn't always correctly understood, this separation stands as a safeguard against governments tempted to assume for themselves the power to direct religious life. It is, again, a limit on government, and such limits, again, are essential to liberal constitutionalism. Our Constitution separates church and state not to confine religious belief or to silence religious expression, but to curb the ambition and reach of governments. In our laws, Caesar recognizes that he is only Caesar, and he forswears any attempt to demand what is God's. Thank you.
Oh, good morning. It's always a pleasure to come back to Notre Dame, and I'm especially happy to be here to talk about this, I think, really important topic with, people who have thought about it. I find this to be a really difficult topic. I think I vacillate a lot in what I think about it. I think a lot of what I've written over the years is classified as like anti-liberal. Micah Schwartzman and others write about me as one of the religious anti-liberals. A lot of the criticisms that integralists make of liberalism seem pretty powerful to me. On the other hand, in my paper today, I argue very tentatively that Christians should be liberals, if I can put it that way. And walking over with Andy, and he said I was really surprised and I think disappointed to see, that you're coming out in favor of liberalism. But I do it very tentatively, and so rather than sort of make an argument here, I just want to talk about the questions that are considered a little bit in the paper that I find to be the hard ones that they have to think about in deciding how to come out on this kind of a question. So, and there are like four. I don't know if I'll get through them all, but so one is just what is liberalism, and we've already heard. And this is true, people define it in lots of different ways. And, a sort of a sensible response to that might seem to be, well, why argue about definition? Some people define it that way. Some people define it that way. You can define it any way you want to. But the problem is for people who are one problem is you're trying to decide whether you're for liberalism or not, you'd sort of like to know. I mean, is there something solid there, or is it just a matter of, defining things you like or things you don't like? Another problem with this, I think, is that there's a lot of risk of people talking past each other. So, for example, with someone like Patrick Deneen, you read his book, Why Liberalism Failed. And yet it seems to me that he's in favor of freedom of religion and freedom of speech and so forth, a lot of things that I associate with liberalism. So, do I disagree with him or not? I'm not entirely sure. In the paper, I try to approach this question, and this is, I think, both my first two questions are kind of like, is there some DNA of liberalism, and what is it? By trying to think of liberalism as a project that arose in response to, in the 16th century, basically the breakup of Christendom and the wars of religion. For a millennium, people have lived essentially in a society in Western Europe in which it was assumed that Christianity, as defined by the Catholic Church, was kind of the overarching structure of truth and authority. And now that wasn't working anymore. People disagreed a lot. And the question was, is there some way we could find to live together with some kind of peace, not under Christendom? And out of that, eventually, I think the answer came, we should just let every person decide for himself or herself, what religion to embrace. And that ripened into kind of a general commitment to a kind of individualism. Individual rights, equality, I think, is closely connected to that idea. And that leads to a couple of other things that almost follow fairly naturally. One is a kind of a detachment. I hesitate to say neutrality, though that's the usual term, and I usually write against neutrality, but at least some kind of a detachment of government from some ultimate questions. And another is a kind of a public and private sphere, so that people could live to some degree in accordance with their own beliefs and so forth, while having a public realm that's somewhat different than that. Those seem to me to be the sort of three maybe essential features of liberalism that grow out of this project, if you can connect them all to this particular project. And in that section of my paper, I suggest that we should distinguish between liberalism as a sort of an approach to governance and modernity. Those get conflated a lot. Understandably, they kind of grew up together. They may arguably have some of the same commitments and so forth. But some of the criticisms that I read of liberalism seem to me like they're criticisms of modernity, but not necessarily of the liberal approach to the pluralism that we face in the world today, that we encounter in the world today, enjoy to some degree in the world today, but also have to confront. So, second question. This has to do with, I think someone in the first panel talked about Adrian Vermeule or Patrick Deneen is referring to some sort of an inner necessity of liberalism, in which some versions of it, like maybe an early version of it, say maybe it prevailed, a Lockean version, or one that prevailed maybe in our founding period or at some period since then, evolves into the kind of progressivism that Andy says is illiberal, that most people here say we don't favor, and so forth. But does the sort of later version is there something in the DNA of liberalism that means that it will sort of almost of necessity evolve into the kind of thing that we say we don't favor? That I think is a really hard question. Some people think there is. Andy says that they haven't shown the mechanism by which this happens, and that might be right. You know, what the mechanism is a hard one, but it may be true. I'll just give you one quick example. If you take religious freedom, which I take to be sort of one of the origins of this liberal project and at the core of liberalism, simplifying greatly, you know, to keep this short, it's arguable, I think, that religious freedom grew out of largely theistic rationales as expressed by Locke, Madison, Jefferson, and others. Then it's at least in some interpretations that have become, you know, dominant today, liberalism means, religious freedom means that government may not rely upon religious rationales or argue from supposed religious truths and so forth, which has the effect of cutting out from underneath the commitment to religious freedom the rationales that gave rise to it. And then there's the risk that it might then become indefensible. And we see, I think, increasing liberals like, Micah Schwartzman, or I don't know if I'd call him liberal, Brian Leiter, but many others arguing there is no good justification for religious freedom today, for singling it out as a special constitutional commitment. And it's a sense in which there's arguably a dynamic within liberalism, within religious freedom, that undermines religious freedom. The question is there something like that about liberalism generally that leads from a healthier liberalism to the kind of thing that we say we're opposed to today? I think that's a really hard question. I'm not always sure what to think about. The answer to that would be. A third question. So in my paper, I talk about ways in which it seems to me Christianity and liberalism are in harmony with each other, ways in which they diverge from each other, and ways in which they conflict with each other. But in that middle category of divergencies, I think there are a lot of respects in which Christianity and liberalism use common terms like freedom, but understand them in quite different ways. I think a paper by Brandon and Father Sergey developed this with respect to orthodoxy at some length and very helpfully. And then the question is, as a Christian, to what extent can you, if you are a Christian, to what extent can you, let's say, use, invoke, even embrace some of the divergent conceptions of things like freedom that are characteristic of liberalism, though they're not the same as your, let's say, Christian views of freedom and so forth, without compromising or in some way betraying your Christian faith. Just to give a couple quick examples, the liberal understanding of the church is going to be really different than the Christian understanding of the church. But does that mean then that Christians should not be able to rely upon, let's say, the very impoverished, much more bare bones liberal understanding of the church as a voluntary association? Is there some kind of betrayal of the faith in doing that? Or is it no? I mean, they're not the same, but they're not necessarily incompatible, and we can still use them. Another area is religious freedom, where there have been critics in recent years who have argued that Christians, like the Christian Baker that we referred to, for example, who claims religious freedom as a reason why he shouldn't have to follow what would otherwise be the anti-discrimination law requiring him to bake the cake for a same-sex wedding. But he's actually betraying the Christian faith in a sense by endorsing a kind of relativism. And he doesn't really believe in relativism. He believes that he doesn't want to do the cake because he thinks that same-sex marriage is wrong or contrary to God's will. But is there really any incompatibility there? Or could we just say, yeah, there are concepts that are being used and they're not the same, but they overlap, and there's nothing wrong with Christians relying upon and using the liberal concepts, even though those don't capture the fullness of the Christian understanding of those same concepts. I think that's a hard question, and people will probably differ on that. The last question, and in some ways, this is the hardest one on a practical level, not necessarily on a theoretical level, but is, if not liberalism, then what's the alternative? People like me, I think, can, again, resonate a lot with some of the criticisms of liberalism and still wonder, okay, but what does that mean? Where do we go from there? And in the last section of my paper, very briefly, I talk about, well, if we look historically, there are those who favor somehow going back to ancient Greece and Rome, the classical antiquity. A lot of problems with that, and may not be a viable possibility. In the Christian vein, well, there are people who argue we are doing that and have done it and so forth, but should that be the ideal? In the Christian vein, and particularly people who are associated with integralism, might look to something more like the period of Christendom of the Middle Ages, and say, well, that's the kind of thing we would want to go back to if we could, or in some way recapture something like that as the ideal that should govern us. And I'm associated with that sometimes. Again, Michael Schwartzman puts me in the neo-medieval category, and so forth. But
You're in good company.
but there are just real problems with that. And I mean, just to mention the most obvious one, it's not at all clear that there's any possibility of doing anything like that in empowering a government then that might have the power to do that today, as arguably Adrian Vermeule would do. The likely result is not going to be anything like Christendom. It's going to be likely as some much more oppressive secular kind of state. And so the question is, what's the alternative? If we look at the 20th century, so, well, there was communism. Would that be the alternative? There was fascism. There's what's going on in communist China today. Is that the alternative? And I think it's really hard to visualize what the alternative would be that Christians might favor. Now, maybe there's a lot of work for imagination and creativity along these lines. But Walker Percy used to say sometimes people would ask him why he was Catholic. And I should say, by the way, this isn't meant to be offensive. I'm not Catholic myself. But he'd say, why is he Catholic? And he would answer, what else is there? And I think a Christian today say, why are you a liberal? You might sometimes say, and this is the position I sort of tentatively find myself in at the moment, say, what else is there? What else is there that, that seems at all even, roughly compatible with the kind of life that Christians will want to lead? And so those are the questions that lead me tentatively in this paper to come out the way I do in favor of liberalism, not in the full-throated way of an Andy Koppelman, but in a sort of concern of what else is there? There are hard questions here, but what else is there? Thanks.
Thank you all so much. So I want the conversation to go pretty much wherever you want to take it. I'll first ask the panelists if they have questions for each other, and then open it up to questions from the audience, giving, I think, preference to the students. But before I disappear, I want to use the privileges of a dying man and ask the first question. So I wanted to zoom in on an issue that I think would face Christians, whatever the dominant form of political life or political philosophy. That is, what is the status or the proper status of the church as a teacher relative to the government, to the state as a governing power? So Professor Brady sketched a picture of that relationship that I would characterize as Socratic. So the church is a model citizen that's engaged in good works, in rallying social forces. Oh dear, the water spill. And involved in dialogue. Now, I will confess, this is my fault, not yours. When I hear the word dialogue, I reach for my pistol. But I will concede that dialogue is not in itself a bad thing, and is maybe even mandatory and can be quite fruitful, but it seems that it might leave something out. So the church may have a kind of Socratic posture at some times, but it's primarily, I would argue, or it's my understanding, apostolic. And so the church doesn't just present themes for discussion. So let's seek for truth together. The church comes to the world and says, I'm an authority, believe me. One of the things, it teaches a certain content, but it also teaches part of the content is its own authority. So if that claim is objectively reasonable, should the church not be asking or inviting the secular power to formally accept its authority to the benefit of everyone, right? If this is a real claim, and that if it did that, would that necessarily result in illiberalism in a scary sense? Some of the reasons you pointed to, Professor Brady, suggest that it might not. And this is the last thing I'll say before asking the question and then opening it up. It's a quote from Professor David Schindler, who tries to play this out. He says, it would be conceivable to have a state that recognizes the authority of the church, and then precisely by virtue of this dependence on the church, can avail itself of all the church's internal resources, her theology of pluralism, her theology of grace as liberating nature's integrity, her natural theology regarding the intellect's capacity to understand God as origin and end, her natural law tradition, her constant insistence on the integrity and capacity of reason, her defense of philosophy in its distinction from theology, her recognition of freedom as integral to the meaning of truth, and so on, and therefore go on to govern the temporal order in a manner that, for example, prudentially recognizes religious diversity. So it doesn't need to acknowledging the authority of the church doesn't entail being illiberal in any sort of obvious or obviously problematic sense. So the question is, should the church encourage the state to not just listen to its opinion, but acknowledge it as an authority? Yeah, please.
That's a great question. And by dialogue, I certainly think the church doesn't have the Socratic model. In fact, that term comes up in biblical sermonic, right? Which embraces religious freedom. And so what does that entail in terms of coming to understand the truth, right? So dialogue, that word comes up in the context of the church playing a role in helping people to understand the truth. So I don't see a division between those. But the question about, so, all right, if the church has this much to say, should we just have a confessional state? And the church's Catholic teaching says we don't need any privileges. It doesn't say we disavow because there are relationships, but it says we don't need that. And there are really rich strains of thought in Catholic social teaching, and there's other strains that are behind liberalism that don't appear so much. And one of those strains is experience. We've talked about that a lot in terms of the foundations of liberalism in general. And I guess I would argue that would be a corruptive influence to have that kind of connection. And I think too close a connection with sort of experience and Western history. I think there's beautiful thoughts, with Innocent III, but it just didn't pan out that way over time. And clearly this would be a slight connection, but I think it would be one that wouldn't be beneficial. The church doesn't want it, and I don't think that it needs it. And granted, a lot of Catholic social thought is very kind of hopeful and beautiful, and then there's reality. But I do think there's something back to the eschatology thing that's kind of sort of built into Christianity, that we're always reaching for something that is only going to be culminated at the end of. There's always a disconnect. So I think the church is comfortable with that. Just saying, go, just want to push, improve, improve.
Other panelists?
Just a friendly amendment, I guess, to your quote from Professor Schindler, Stefan. He talks about prudentially recognizing religious diversity, and I guess as I understand, in the Catholic tradition anyway, where we are on religious freedom questions, is that the church is committed as a matter of principle to religious freedom, in the sense that power of the state is not to be used to coerce religious exercise or religious profession or what have you. That's consistent, at least according to the Second Vatican Council, with there being, sort of soft forms of establishment in some places. There's variation there, but if Schindler's suggestion is that kind of, as a concession to the unhappy fact that we haven't all arrived at the same place, the state might, as a matter of prudential reason, recognize religious freedom. I guess I wouldn't accept that.
What about, before asking Professor Smith, just to sort of clarify, because I think one of the things he has in mind is, for example, if you're the Supreme Court and you're determining so what a gay marriage is required by the Constitution, a sort of binding legal source would be what the church says marriage is. So would that kind of official recognition be something that's problematic?
Yeah, I think in my view, it would be problematic. I mean, I think for several centuries now. But the church has talked more in terms of sort of indirect influence in that sense rather than direct. I don't think there's a constitutional or religious freedom problem with the church proposing its views and with religious communities sort of shaping their believers to have certain views about public policy questions, and for those public policy views to be enacted into law via the constitutionally ordained positive law mechanisms. But in terms of kind of just incorporating by reference into the civil law the teaching authority of the church, I think we have rejected that.
Well, I guess I'll say a little. So first of all, I'm less qualified as when I talk about church, I'm using it more in, I suppose, a big tent sense, not just the Roman Catholic Church and so forth. But I at the end of my remarks, I said, I think we need to do a lot of work in imagining alternatives. What are the alternatives? And people like David Schindler are doing that, I think. So I think they're doing a very valuable work in trying to do that. And I think, in a way, it's an interesting point that he makes that, today, a lot of people would say, oh, any sort of relationship with your church and state of the kind he talks about would be automatically, by definition, a severe violation of liberalism. And I think that's not necessarily so, and it's worth thinking about things of that like that. I also, just to add, I totally agree with what Professor Garnett said about Christianity and the church being, maybe essential to liberal democracy. But I've never actually disagreed with anything Professor Garnett that I've heard him say, so that's not surprising. But I think that's an important point, because whether you think liberalism is a good idea or not, I just think it's obvious that liberal democracy is in deep trouble today, and so you have to start thinking about, how could it be salvaged and so forth. And I actually think something like a revival of a more Christian and church influence might be the only hope. Sometimes I think that. And when I think that, I also think, but one of the problems is that the church today, again, in this looser sense, is not very well positioned to provide that service, because the churches, I think, in various ways, have all compromised, let's say, their ability to be that sort of an authority. And one of the ways in which they have done it, I think, is in some cases, this obviously varies from one church, there is unwillingness to speak in the way that Professor Schindler says they should.
I don't know what you're talking about.
I think they would need to. That's one thing that would probably need to happen for churches to be able to serve this role better. So in that sense, in the end, I don't see it as a viable possibility within our system, though, and our tradition for anything like that to evolve.
Any questions for each other before we open it up? Okay, questions from the audience.
So just on the question of what else is there, and the question is it possible under modern conditions to have a regime like the one that India contemplates, where you've got a political authority that also bears religious authority, and uses the powers of the modern state in order to enforce its religious vision? You don't want to look at the Soviet Union, you want to look at Iran, because it actually is, under modern conditions. And you say that in the paper that individualism is the core of both liberalism and modernity. Well, Iran is not individualistic, it's not liberal, but it is trying to get a nuclear weapon, which is an extremely modern thing. So I think that that's the real rivalry, and it seems to me that needs to be juxtaposed with the real, because it's clear that quite a lot of the governments in Iran, you've got true religious believers, but it's also clear that you got a big constituency of kleptocrats, particularly in the army, and if the regime is stable, which is where that's the actual alternative to liberalism that's on the table. And I don't feel particularly bloodless or uninspired when I take a look at Iran as the alternative. And I would say, you quote a liberal as a man too broad-minded to take his own side in the quarrel. We are, in fact, at war with Russia. We've got other troops in Ukraine. The Ukrainian troops have just entered Kherson. I would suggest that the Ukrainian troops entering Kherson are an instance of a liberal taking his own side in law.
Well, that was directed to me, I guess. So The Iran point, the Iran point just reinforces my, I said, it's hard to imagine, attractive alternatives. And so if you want to put Iran out, there's another alternative. Okay, but that's not an attractive alternative either, I think. The part about being too, that's a quote often made from Robert Frost, where he says, the liberal is somebody who's too broad-minded to take his own side in an argument. And all I do that is raise a question. One of the vulnerabilities of liberalism, I think, is that insofar as it is supposed to be, insofar as, you're probably more on board with this than I am, but insofar as one of its commitments is to be neutral with respect to ultimate truths, it makes it difficult for liberalism to come up with good justifications for itself. That's the only point. I think that's a potential point of vulnerability in liberalism.
Yeah, I guess this is speaks to Kathleen's paper. Comprehensive liberalism, it's there as part of the overlapping consensus, and even the idea that there are plural ways of life, and you can make lots of choices among them, and they are rationally underdetermined. You just gotta look within yourself to figure out what you want. Well, that's what Robbie George and John Finnis think about. Huge range, but the immediately existential question for the undergraduates here: what shall I major? You've got to be very much like what John Stuart Mill describes in chapter 3 of On Liberty. You got to try to figure out which of your potentialities you most want to develop. So lots of room for overlapping consensus.
Professor Moschella.
So I think a thread on the panel is the way in which liberalism is dependent on Christianity, in part because it lacks the theoretical thickness to justify its own deepest values and presuppositions. And this is something that many liberal thinkers, including non-Christian thinkers like Habermas, for instance, have recognized, that the commitments, deep commitments to human equality, to human dignity, to freedom, that it's no surprise that this tradition came out of the Christian West, because these are deeply Christian values. And so then the question becomes, can liberalism sustain itself and sustain these values in their proper order without taking them sort of out of order in ways that become illiberal? Can liberalism do that in the absence of kind of robust Christianity in civil society? And if it can't, then the question becomes, what can the state do compatible with limited government and liberal principles to favor and foster the sort of robust religious belief and activity and association in civil society that it requires to continue to flourish?
Professor Brady.
That's a great question. And I think that the idea in current Catholic social teaching is facilitation, right? Rather than direction, facilitation. And facilitation that certainly means strong religious faith, right? And that would help a lot. I think some of our current fights have been, there's been a contribution by overly narrow views of religious freedom, that we've gotten to sort of a terrible point of animosity that would probably have been better with stronger views of religious freedom at the beginning. But that's just sort of a baseline. And so beyond that, I personally believe that too much contact between religion and government, that can go quite bad places. So I guess for me, the biggest role for facilitation would be religious freedom. But you are writing with parental rights, so there you go. I mean, that's developing another right, that can strengthen the role that families play in civil society. So that's kind of another liberal direction to developing the country. But it's excellent.
Thank you. That will have to be the last word. Please join me in thanking our panelists. And we'll be back in 10 minutes.
Third We have 2 people here present and 1 over Zoom. And so let me introduce our speaker over Zoom first. This is Paul Billingham, and he is an associate professor of political theory and a fellow of Magdalen College at the University of Oxford. His research primarily focuses on debates within political liberalism and concerning the place of religion in public life. This has included engagement with Christian theology in order to examine the compatibility of Christianity and liberalism. His work has been published in numerous journals and in moral, political, and legal philosophy. He is currently co-authoring a book, Does Faith Belong in Politics? A Debate, to be published by Rutgers. His other current main focus is collective religious liberty. Now we have our second panelist. This is Melissa Moschella. She is an associate professor of philosophy at the Catholic University of America. Her work focuses on natural law, biomedical ethics, and the moral and political status of the family. In 2016, Cambridge University Press published her book titled, To Whom Do Children Belong? Parental Rights, Civic Education, and Children's Autonomy. Dr. Moschella speaks and writes on a variety of contemporary moral issues, including brain death, end-of-life ethics, parental rights, reproductive technologies, and conscience rights. Her articles have appeared in leading scholarly journals such as Bioethics, the Journal of Medical Ethics, and the American Journal of Jurisprudence, as well as popular media outlets such as the New York Times and USA Today. Dr. Moschella received her undergraduate degree from Harvard College, a licentiate in philosophy from the Pontifical University of the Holy Cross in Rome, and a PhD in political philosophy from Princeton University. This brings me to our third excellent panelist. This is Amy Sepinwall. She is an associate professor of legal studies and business ethics at the Wharton School of the University of Pennsylvania. Dr. Sepinwall's research focuses on corporate constitutional rights, gender and racial justice, individual and collective responsibility for corporate and financial wrongdoing, and law and religion. Her broad-ranging scholarship has appeared across an array of top journals, including the Journal of Corporation Law, Constitutional Commentary, the Washington University Law Review, and the University of Chicago Law Review. Dr. Sepinwall received her law degree from Yale and served as a clerk to the federal district judge, Lewis Pollock. She holds a PhD in philosophy with distinction from Georgetown University and a master in bioethics from McGill University. With that, we will begin. We'll begin with our remote panelist, Dr. Billingham.
Great. Thanks a lot. Good morning, everyone. I'm assuming someone will wave at me if you can't hear me. So if I see no waving, I'll assume you can hear me. Thanks so much to Professors Brady and Chapman for inviting me to participate in this symposium. It's great to do so, although a big shame I couldn't do it in person and instead have to appear as a giant floating head. But that's better than nothing, I suppose. And thanks as well to anyone who's read the version of my paper I submitted. If anyone has any written comments on it, please do send them to me. Obviously interested to know what people think. So the focus of my paper is on the place of religious reasons in democratic deliberation. And in many ways, that's very well-worn territory. Many of you will probably be familiar with debates about public reason and with objections to public reason liberalism that have been presented by many people, including Christian critics. So, for example, according to Oliver O'Donovan, public reason offers us reason as a predetermined quantity, ready sliced and ready packaged. It does not invite us into discursive engagement as human thinkers with other human thinkers on matters of common concern. The demand that religious citizens bracket their religious convictions when they engage in democratic deliberation, quote, severs many citizens' deepest religious or moral commitments from their political deliberations and actions, close quote, as Jonathan Chapman puts it. And it also undermines their integrity, according to a well-known objection from Nicholas Waterstorff. Now, a common response to these kinds of objections has been to say that they often assume what we can call an exclusivist public reason view, according to which there's a duty not to offer religious reasons in public deliberation and instead to only offer public reasons. But few public reason theorists actually endorse that view. Most adopt some version of inclusivism, which permits the offering of religious reasons, even while limiting the role they can play with respect to providing the final or ultimate justification for laws. But even those who permit religious contributions to democratic deliberation usually provide little reason to think that those reasons can play a persuasive or fruitful role within it. Indeed, public reason theorists tend to hold that religious reasons are inaccessible to others due to being based on beliefs and values others don't share, and that's why they shouldn't be the basis for law. But that inaccessibility also seems to suggest religious reasons can't do much good in deliberation. Other citizens are unable to assess their validity, critically engage with them, see them as having normative force. Religious reasons can't advance debate, provide arguments others can respond to, grapple with, be persuaded by. So it's permissible to offer them on inclusivist public reason views, but it looks like it might be rather pointless. There's no duty to refrain from doing it, but they still might be conversation stoppers, to use Richard Rorty's infamous term. And so the aim of my paper is to challenge that thought and to argue that religious reasons can play a much more meaningful and fruitful role in deliberation than it says. Others can, in fact, understand, critically engage with, even be persuaded by religious arguments. And further, this can affect what laws are enacted through the way it influences other citizens' views and the exercise of democratic rights. So religious reasons can have a much more positive, shaping role in democratic deliberation and decision-making than their purported inaccessibility would imply. And further, I'm trying to argue that that can all be true in a way that's perfectly compatible with public reason liberalism. So it's true even if public reason liberals are right that religious reasons are inaccessible in a way that means they shouldn't ultimately justify laws. My argument is that such reasons can nonetheless be accessible in a less technical sense of the term. And that kind of accessibility is sufficient for playing a fruitful role in political deliberation and decision-making, even if it's not sufficient for being a public reason. So one way to understand what I'm trying to do here, I think, is that I'm working within liberal theory to explore how much space even public reason liberals should make for religion. And the upshot of my argument, I hope, is that they should be more positively disposed towards religious contributions to democratic deliberation than maybe they tend to be. They shouldn't just permit them, as many do, but they should positively welcome and encourage them. And that, I hope, provides a stronger response to some of the Christian objections that I mentioned earlier. Now, to be clear, I in no way think this somehow diffuses all Christian objections to public reason liberalism or liberalism more generally. There are a host of deeper objections to do with liberalism's anthropology, conception of freedom, and so on. We've heard quite a bit about that already. So I'm not claiming I've dealt with all of that by any means. Instead, I just hope to show that liberalism, even public reason liberalism, can be much more open to religion than critics usually think. Liberal public political culture can and should be religion friendly, and that makes some form of rapprochement more likely. Although, having said that, I recognize, or at least I learned from Professors Brady's paper, that Adrian Vermeule isn't interested in the latest minor paper on Rawlsianism, which I take mine might be. So he's not going to care, but there we go. Okay, so that's an explanation of what I try and achieve in this paper. The way I go about it is by exploring in a reasonable level of depth two arguments from Christian theologians. So one is an argument from Nigel Biggar against the legalization of euthanasia, and another is from Luke Bretherton arguing for a cap on interest rates on unsecured personal loans. And both arguments are thoroughly theological, but in both cases I identify various ways in which non-Christian interlocutors could investigate, critically engage with, be persuaded by the argument. And in the full paper along the way, that leads me to some further discussion about the nature of the idea of accessibility in public reason liberalism and some critical discussion of Jürgen Habermas's view. But for the time I've got now, I just want to say a little bit about Bretherton's argument and what I say about his argument to give a flavor of the discussion. So that argument from Bretherton has various elements that I can only gesture toward in the time here, but he appeals to the central role that the idea of freedom from debt slavery plays in a biblical understanding of salvation, to Old Testament laws prohibiting usury, to biblical understandings of ownership, stewardship, and the power of money, and to patristic and Reformation discussions of the distinction that we might want to make between legitimate interest and illegitimate usury. And these various theological strands of argument lead him to an understanding of lending and borrowing as good things, but ones that need to be regulated so that they don't lead to exploitation, oppression, or abuse. So he thinks that charging interest on loans can be permissible, but only within limits that protect the poor and vulnerable. And as a result, he supports a 20% cap on interest rates on unsecured personal loans, which was actually a policy that was part of a package of policies that a group called Citizens UK were pushing at the time. And Bretherton's really providing a kind of Christian justification for the policies that they were promoting. Okay, so this Bretherton's argument isn't accessible in the public reason sense. Those who don't share Christianity's epistemic commitments aren't going to see biblical and theological sources that it relies upon as giving them reasons to endorse Bretherton's conclusion. But the argument can still make a fruitful contribution to democratic debate about this issue, at least when fleshed out more fully than I've had time to do here. So firstly, non-Christians can certainly understand the argument. It's intelligible. Second, they can also assess its plausibility on its own terms. So they can take, for the sake of argument, Bretherton's sources as authoritative and press back against aspects of the argument. So to take one example, Bretherton admits that Israelites are allowed to charge interest to foreigners, apparently without limit. And plausibly, you might argue that our relations in large, pluralistic contemporary societies are more like the Israelites' relations with non-Israelites than with their fellow Israelites. We don't live in a small, close-knit fraternal community. We interact in a large, impersonal financial system. So you might think that the Old Testament restrictions on usury or limits on interest don't carry over. And that kind of thought might cast doubt as well on the applicability of the model of sharing and debtlessness that Bretherton highlights as exhibited in the early church. So secondly, we can do this kind of internal engagement. But third, and most importantly, I think, Bretherton's argument can be persuasive to non-Christians, to those who don't accept his kind of epistemic sources. It contains various insights others can find compelling and wish to accommodate into their own views. Those include insights into the nature of human community, the way money can generate significant social power, the possibility of unfree consent, the possibility of seeing our relation to possessions as one of stewardship rather than ownership. Part of what Bretherton's trying to show is that if we understand the Old Testament's anti-usury laws in the light of the way financial power dynamics played out within the agrarian economy of the time, we can see the wisdom of those laws. And then we can draw insights from that into the operation of that same kind of financial power today, and therefore the need for regulation in our context. And that could certainly be persuasive to someone who doesn't consider the Bible to be authoritative. So in sum, the claim is that discursive consideration, critical assessment, points of persuasion, borrowing of moral insights are all possible in relation to Bretherton's argument, and its religious character doesn't stand in the way of any of that. And then further, those kinds of responses can affect what laws are enacted. Citizens can be persuaded to support a law such as the one Bretherton is pushing or endorsing in ways that they otherwise wouldn't endorse that law. Non-Christians aren't going to support it for exactly the same reasons as Bretherton, but they're going to borrow moral insights and develop their own arguments drawing from their own moral sources. And then those arguments might prove persuasive to others. And in that way, what Benjamin Hertzberg has called a chain of persuasion can form. So at the end of the paper, I borrow from Hertzberg's helpful account to draw out some of these more systemic implications of my argument. So, as I said right at the beginning, debates about religion and public reason are well worn. But my hope is that this paper does something a little different by engaging more closely with some actual real-life examples of religious political argumentation to examine the place that they could have within pluralistic democratic deliberation. And I hope that what I show is that liberals can and should be much more open to religious contributions to deliberation than their critics assume, and perhaps that sometimes they themselves tend to assume. So I'll finish there. Thank you very much.
Thanks very much to the organizers for inviting me, and to everybody for coming out at a very busy time of year. So my paper offers a natural law-based defense of limited government, including in particular respect for parental rights.
And it does this through an analysis of the Mortara case, which I'll describe in a second, and what I consider to be its contemporary progressive parallels. So in brief, what happened in the Mortara case is that a boy named Edgardo Mortara, born in 1851 of Jewish parents in the Papal States, was secretly baptized by his Catholic nanny when he was in danger of death as an infant. Several years later, when he was about 6 years old, Pope Pius IX heard about this, and he ordered that Edgardo be removed from his parents' custody so that he could be educated as a Catholic, a right that he had by baptism. Catholic integralists have recently defended the Pope's action on the basis of key premises of integralism, namely that it's unproblematic for civil and ecclesiastical authority to be united, that the priority of spiritual or supernatural goods over temporal goods translates into a justification for the use of coercive civil power to achieve spiritual goods, even in cases where this is contrary to parental rights or other civil liberties. Now, I argue in the paper that these integralist arguments are contrary to the Thomistic natural law principles that they claim to espouse. At the same time, I also recognize that Catholic integralism is, to a large extent, a reaction against increasingly intolerant contemporary progressive forms of liberalism. And I highlight the striking resemblance between the integralists' defense of taking Edgardo Mortara from his parents in order to promote his good as they understand it, and contemporary progressive arguments to override parental judgments and sometimes even terminate custody in the name of promoting the good of children as they understand it, in particular, in the name of allowing gender dysphoric children to receive so-called gender-affirming medical treatments. Before developing this parallel, however, I present a natural law case for limited government in general and for parental rights in particular, and use that argument to show why I think the proposals of both the Catholic integralists and their progressive counterparts are fundamentally unjust. So let me briefly summarize that case here. So the natural law view that I'm working with is the so-called new natural law theory, which John Finnis applied to legal philosophy in his book, Natural Law and Natural Rights. According to this view, morality is about respecting and promoting the integral flourishing of human persons, both individually and in community. And the basic dimensions of human flourishing, things like life, knowledge, friendship, integrity, religion, and so on, are basic human goods. The standard for morally upright action is the ideal of integral human flourishing, the flourishing of all human beings with respect to all basic goods within a harmonious community. This standard can be fleshed out in familiar intermediate moral norms, things like prohibitions on intentional harm to basic goods, which would be the basis for things like inviolable human rights, as well as norms forbidding arbitrary prioritization of one person or one good over another, like the Golden Rule, or the requirement to establish a reasonable order of priorities in one's life on the basis of vocational commitments and other obligations. Now, these basic principles provide the foundation in natural law thinking for politics and law. The moral imperative to promote integral human fulfillment, combined with the fact that human beings can only flourish in community, and that some political communities, like the family and civic associations, are not self-sufficient to achieve their ends and to meet the full range of human needs, is the basic justification for political community and political authority. Subpolitical communities lack self-sufficiency regarding four broad types of needs that require mutual coordination and thus an overarching coordinating authority to justly and efficiently address. First, provision of public goods and services. Second, defense against external threats. Third, protection from internal threats and administration of justice.
And fourth, providing for the needy who have no one else to care for them. Broadly, I call these needs coordination problems. The specifically political common good, the purpose of political community and the justification for political authority, is to resolve these coordination problems, facilitating the pursuit of flourishing by the individuals and subpolitical communities that make up the political community. This purpose of political community can be summarized as peace and justice. Now, because political authority has this limited purpose and justification, it also has a correspondingly limited scope. The limits on political authority are requirements of justice, which I'll list briefly. First, positive law must be in line with natural law, for no law contrary to natural law can actually promote the common good. However, political authority is limited to forbidding serious other regarding harms, and the use of political authority for primarily spiritual ends or private morality is out of bounds, precisely because the government's sphere of competence is limited to temporal peace and justice, which means other regarding actions. Another set of limits on government flows from recognizing that freedom is required for the pursuit of many human goods, and thus that the protection of various civil liberties, freedom of speech, association, religion, economic freedom, and so on, is crucial to the political common good. Natural law also recognizes the political community and corresponding political authority as subsidiary. In other words, its purpose is to assist the more basic sub-political communities like the family that compose it, not to usurp their proper sphere of competence and authority. And I'll come back to this when discussing parental rights. And finally, there are procedural limits on the exercise of political authority. For natural law requires the government generally exercise authority through the rule of law within a constitutional order. The rule of law provides the clarity, stability, and predictability that is necessary for people to be able to pursue their good, and that embodies a spirit of reciprocity and mutual respect between ruler and ruled. So the natural law, as you can see, coincides with the liberal account in many of its conclusions, but the grounds for those conclusions are different, based not on any attempt to be neutral about the good, but rather precisely on a substantive vision of human flourishing and what is required for that flourishing. So let me say a bit now about respect for parental rights as essential to limited government. On the natural law view, the family is the basic unit of society and is itself a basic human good. A central aspect of the common good of the family, headed by parents, is the raising and educating of children. The authority that parents have over their children is natural and pre-political, based on the nature of the parent-child relationship, not derived from political authority. Aquinas speaks of the family as a spiritual womb, a continuation of the mother's physical womb, within which the child can grow to full human maturity. The spiritual womb is a metaphor for the sphere of parental decision-making authority, a sphere within which parents make judgments about what is in the child's best interests until the child reaches maturity and becomes capable of rational self-governance. This metaphor suggests an analogy between the family and the sovereign nation. Generally, coercive intervention by the international community into the internal affairs of a sovereign nation is justified only when necessary to stop grave human rights abuses or for the preservation of international peace and order. So it is with the family. Political authorities are not justified in intervening coercively in the family sphere merely because they disagree with parents about what is best for their children. Rather, coercive intervention is justified only in situations analogous to those that justify international intervention into the affairs of a sovereign nation. That is, when parents have demonstrated themselves to be unfit through genuine abuse or neglect, or when their actions constitute a direct threat to the public order. The state does, of course, have a legitimate concern for the education of future citizens, and on this basis, it can make laws ensuring that parents fulfill their educational responsibilities and can facilitate this by providing public schools or educational funding. The Supreme Court's rulings in Meyer v. Nebraska and Pierce versus Society of Sisters are in line with this natural law tradition seeing compulsory education laws as enforcing an obligation that belongs primarily to parents, and recognizing that the state's sphere of competence in the educational arena is limited by the natural authority of parents, and that respecting that authority is essential to limited government. Now, the application of these principles to the Mortara case are fairly straightforward, regardless of whether or not Mortara's baptism was valid, though I actually think there are good theological reasons for questioning that. It was beyond the state's sphere of competence to substitute its judgment about Edgardo's best interests for the judgment of his parents. What about the parallels to what I call contemporary progressive integralism that wants to override the judgments of fit parents who object to so-called gender-affirming treatments for children with gender dysphoria? I provide several examples of this in the paper, including California's recently passed transgender refuge law, which allows the state to take custody of minors who travel to California seeking gender-affirming care against the wishes of their parents. I also discuss several articles by medical ethicists and legal scholars that would justify such overriding of parental rights on the grounds that it's necessary to protect the rights of gender dysphoric children as they understand them. So just as in the Catholic integralists' defense of the Mortara case, these authors defend state intrusion into parents' sphere of authority on the grounds that it's necessary to protect the rights of the child, respect the child's identity, and preserve the child from harm. While they have diametrically opposed views about what actually counts as harm or as promoting the child's good, they both justify substituting the state's judgment about what is best for the child for the parents' judgment. And here I note that there's widespread controversy in the medical community about how best to help children with gender dysphoria, with most European countries now backing away from the gender-affirming approach. Given this controversy, it seems untenable to claim that parents who don't believe this approach is in their child's best interests are guilty of medical neglect. And more generally, the natural law argument indicates that state intervention should be limited to cases in which harm to children is clear, serious, and non-controversial. Both the Catholic and progressive integralists clearly run afoul of this principle. So to conclude, I've tried to show that the natural law tradition can offer a robust defense of the principles and institutions of limited government that are frequently associated with liberalism. And I've also tried to show that both left and right versions of integralism violate these principles, something which each side should regard as a cautionary tale, for there's no guarantee that your people will always be the ones in power. Ultimately, both political prudence and the very real harms that result from violating parental rights and other civil liberties underscore the wisdom of limited government and its crucial importance for the promotion of integral human flourishing. Thank you.
Good morning. So I also want to begin by thanking Nate and Kathleen for inviting me, Amy for your organizational efforts, and then especially the students on the Notre Dame Law Review, in particular, Nicholas, Megan, and Courtney. You all have been so attentive. You are primarily budding scholars, not travel agents, and yet the level of detail that you have afforded is really remarkable and very much appreciated. With that, I'll shift to my paper. So my paper starts from a puzzle, and the puzzle is that we see an array of complicity claims, claims that individuals make that some regulation subjects them to a conscientious violation, and the court's response is not at all uniform. Instead, what I note and what I'll aim to describe here is that, thank you, yes. No, you're good. The misfortunes of being not that great in stature. So the court has diverging responses to these complicity claims, and the pattern that I note and that I seek to make out is that the court is much more willing to recognize complicity claims that arise where something monetary is at issue relative to other kinds or other forms of implication. And I seek to draw out this asymmetry through a number of cases. And again, I'll give you some examples in a few moments. And then what the paper tries to do and what I'll end up trying to do very briefly here is to try to shed light on why this divergent treatment might arise. And to that end, I'll offer Christian and liberal understandings of complicity to understand and critique this divergent treatment. But I should say at the very outset that this project is foolhardy in a number of ways. I'm just going to highlight two of them, although perhaps others will come out in the Q&A. It's foolhardy for one thing because it's transsubstantive, right? So it's surveying a great array of doctrines, in none of which am I an expert. Suffice it to say, I'm certainly not an expert in all of them. And then on top of that, it aims to say something that relies on Christian thought, and I am an absolute novice in that space. So in many ways, the paper operates at sort of the height of chutzpah. I take that to be a Christian term of art, right? See, I'm learning stuff. But yes, I will very much look forward to all of your comments and feedback for that reason. Let me start with the cases, though. The cases survey three different areas. One of them is compelled hosting, a second is compelled support, and a third is a line of cases where the court seems very anxious about money's fungibility, and I'll take each of those in turn. So starting with compelled hosting, here the paradigmatic contrast that I'll provide for you today is between the Solomon Amendment cases. These are cases where law schools objected to the military seeking to recruit law students on campus. The law schools objected to the military's recruiting on their campuses because the military refused to adhere to the law school's non-discrimination policies. And so the law schools sued, claiming a First Amendment violation. This was an interference with their freedom of speech and freedom of association, and the law schools lost. Contrast that with a 2021 case that the Supreme Court decided called Cedar Point Nursery versus Hasid. That was a case involving an agriculture business in California. And California had passed a law that said that if you run a agriculture business, you have to permit labor organizers to enter your property for a minimum of 3 hours a day on as many as 120 days per year. And the agriculture business sued, claiming, just like the law schools had, that this was a kind of forced intrusion. The agriculture businesses sued not on First Amendment grounds, but on takings grounds. So according to the agriculture business, allowing these labor organizers onto their property involved having the labor organizers appropriate the property such that a physical taking had occurred, and insofar as a physical taking had occurred, the business was entitled to compensation. So both cases, again, seem to involve intrusions onto one's property. Both of them have to do with employment or labor purposes, but as I said a moment ago, the law schools lost and the agribusiness wins. And the implication that I seek to draw is that the court seems to care more about money than messages. The fact that the law school's integrity or ability to live out what might be central to its values was of little moment to the court, whereas the fact that the agribusiness was going to have its financial interests set back by allowing labor organizers into the property seemed to be much more meaningful. So that's just one pair of cases within this umbrella of compelled hosting. On the compelled support front, here I contrast Hobby Lobby and the wedding vendor cases. I know these cases are typically paired together, but it's meaningful from my perspective that Hobby Lobby wins on the merits, and so far at least wedding vendors have not won on the merits before the Supreme Court. So I'm sure you're very familiar with both sets of cases, but very briefly I'll go through the facts just in case. Hobby Lobby is a for-profit, closely held corporation whose owners object to certain forms of contraception. The Affordable Care Act mandates that employers provide healthcare, which will include coverage for the forms of contraception that the employers oppose, and the employers raise a religious freedom claim to receive an accommodation such that they don't have to subsidize contraception. The court agrees that there is what I'm referring to as complicity, and it allows Hobby Lobby not to have to pay to subsidize contraception. The wedding vendor cases also involve conduct that is believed to support an intimate activity that the wedding vendors oppose on moral grounds. So most famously in the Masterpiece Cake Shop case, the baker wants not to have to provide a wedding cake for a same-sex wedding. And again, the baker does not win on the merits. He wins on what some people might say is a technicality. Some people think that the Supreme Court punted in the case, but basically the Supreme Court holds that the baker didn't receive fair treatment in the courts below, and so it just remands the case without deciding the key questions, that is whether the baker would have been subject to a violation of his religious freedom or free speech claims. The court does, though, and this is important for my purposes, suggest that it would be skeptical that someone in the commercial sphere could at least raise a freedom of religion objection to an anti-discrimination law, right? So it looks like the court is much less hospitable to the baker's claim than it is to Hobby Lobby's claim. Hobby Lobby is implicated by way of money, right? The mode of implication is that it would be paying for insurance through which people would access contraception. The baker, on the other hand, seems to be providing something that one would take to be much closer to the self, which is to say, blood, sweat, tears, possibly creative energies. I think we tend to think of a person's creative product as being more them than their money is them, and yet the court seems to see it in just the opposite way. The last set of cases doesn't proceed by way of contrasting a case involving money and a case involving a different mode of implication. Instead, it just seeks to draw out how very impressed the court seems to be by money's power and reach by surveying a line of cases where the court sees complicity through money, even though the money that is supposed to be implicating makes its way to the end for which the actor is deemed complicit, and only the most indirect, circuitous route. And a key example here involves the material support cases. So these are cases involving individuals who want to provide some kind of assistance. Sometimes it's monetary, sometimes it's training, advocacy for groups that the State Department has deemed terrorist organizations. But many of these groups have peaceful wings, and the aid where the contributors are challenging is aimed to go to the peaceful activities of these organizations, right? These are liberation movements, and they're individuals who want to be able to support the liberation movement's efforts. They are subject to criminal liability because even while they're aiming to support peaceful activities, the court is extremely concerned that they're doing so is somehow going to free up money that the organization will be able to direct to its terrorist activities, right? So cases where you're not contributing money at all, but nonetheless, money is so powerful that if you do something that has any kind of monetary value, the court is going to trace the money or trace your contribution and translate it into monetary terms such that you are now complicit in terrorism. So again, 3 different areas of doctrine, all of which are supposed to help make the case that the court is very attentive to monetary complicity and far less attentive to non-monetary forms of implication. And of course, the question then arises, okay, what are we supposed to make of this divergence? Where does this divergence come from? What can we learn from it? And by way of answering that question, I seek to draw out a contrast between the way that Christian thought on the one hand and liberalism on the other conceives of pecuniary complicity or monetary complicity. So moving very quickly here, on the Christian thought side, it seems like what's paramount is a desire to safeguard individuals from impurity. So market participation is seen as an unfortunate necessity, and through market activity, one is going to unwittingly become involved in someone else's wrongful conduct. And the important thing to underscore here is the conception of money that seems to be at issue, which is one according to which money is a medium that taints. So money is like an infecting agent. Money is the bad thing. It is separate from the self. And I think that one can draw a contrast here with the way that the court seems to understand money, which is far more secular. So I should say first that the complicity cases are much more puzzling for liberalism. We've heard Emory's points today, that liberalism is very much about the individual. Once you have this very individualistic orientation, you're going to be inclined to conceive of the scope of any person's responsibility as being quite narrow. So it's very hard for the liberal to make sense of one person's being morally responsible for the wrong of some other person, which makes, again, the court's solicitude for these pecuniary complicity cases all the more puzzling. So how is it that the court manages, notwithstanding its liberalism, to see complicity where money is the implicating factor? I think the answer to that question is that the court sees money as being an extension of you. So unlike the Christian view, which sees money as being this thing outside of you that infects you, I think according to the court, it's fair to say that money is you in some sense. And if you are your money, then the things that your money is going to support are the things that you yourself are going to support. So I'm going to end there because I'm out of time, and very much welcome your comments and feedback.
All right, thank you all to the panelists. I think in the interest of time, I will go right to the audience. I know our speakers have a chance to talk to one another. You can interject if you want, but let's go right to the audience. It would be great if you would say your name, anything else that's relevant, and then ask your question. So any questions from the audience? Yes.
Right up there, right? First
Thank
question, Isn't, what would you say the following kind of objection? The difference between those two cases you talked about is the child in sort of modern case is consenting or is sort of desiring this treatment, whereas in the table stakes case, maybe we don't know what the child wants, or let's stipulate not desiring conversion or whatever.
Yeah, so I mean, one interesting factor of the case is if you accept the authenticity of the memoirs that were recently published, though there are doubts about that. But anyway, Edgardo, I mean, a 7-year-old never likes to be taken away from his parents at age 7. However, Edgardo later praised the Pope for his actions, was extremely grateful, went on to become a Catholic priest. And so retrospectively, one might say, consented to the actions. By contrast, if you look at the kind of growing number of detransitioners and cases like the Kirabel case in England, a lot of the children who at age 10, 11, 12, 13, 14, 15 really say that they want and need these treatments, puberty blockers, cross-sex hormones, et cetera, in order to lead happy, fulfilling lives, sometimes 3, 4, 5, 10 years later, realize it was a terrible mistake and are left with irreversible changes to their bodies and lifelong health sequelae of these things. So, I mean, I think it really all comes down to the fact that nobody really thinks that 10-year-olds or even 14-year-olds have the capacity to make irreversible decisions about their lives. And in all areas of law, we generally recognize that. We don't allow minors without some adult supervision to make these life-changing sorts of decisions. So even in this case, everybody agrees that somebody else, some other adult, has to agree with the minor's view, right? It's not that the minor just gets to call the shots. It's that there are some adults who think the minor is right, and there are other adults who think the minor is wrong. And so the real question is, which adults have the authority to decide what is in the best interest of a particular child? And the argument, I think, both from prudence and pragmatism, that the court has recognized in many cases that there's no reason to think, on the contrary, that the state is likely to be a better judge of a child's best interest than parents, or to be more motivated to pursue the child's best interest than parents. So that seems prudentially to be correct. But then also, again, from a fundamental authority perspective, it seems that when you have to make controversial judgments about what's best for the child, that lies with the parents. So I think the burden of proof is to say, unless what the parents want to do is clearly abusive or neglectful, and by clearly, I mean, there has to be basically no major controversy about whether or not it counts as abuse or neglect. So anything that a significant portion of the population thinks is good or at least acceptable, I think couldn't count as abuse or neglect, and that's what's going on here.
All right, Professor Garnett.
Amy, two quick questions. One, I wondered, do you think that every compelled expression claim is a complicity claim, or either as a matter of morality or doctrine, we want to have some distinction between compelled speech cases and these kind of complicity arguments? And the second question, the example I was thinking of, I'd be curious to see how you approach this of the money flow and conscience problem. The classic example, it seems to me, is the whole anti-school funding argument that's rooted in Jefferson's letter that's underlying the Glass-Cohen exception of taxpayer standing. And Justice Souter certainly wrote a lot about it. The idea being that it's a unique imposition on conscience to have one's tax dollars, which ordinarily are, not yours anymore, but to have one's tax dollars go to religious purposes. And so we create again, an exception to the standing rules. And for a long time, we said the downstream use of this money by religious institutions was unconstitutional itself. So how does your kind of framing of these three pairs, where would you slot in the Glass-Cohen debate?
These are terrific. Try to be brief. Is every instance of compelled expression an instance of complicity? So it certainly seems like a lot of the time, some of the complaints are raised explicitly in terms of, it's not that we have a moral objection to this message. It's instead that you're recruiting us into promoting the message, and we oppose it on some other ground, but we oppose it because it's in some sense going to set back our business interests. So I see the analytic distinction, but I also think that a lot of these complainants are slippery, so they will seek to rely on rhetoric around, you're compelling us to promote a message that we disagree with without specifying that the disagreement isn't moral. And or the thought that, like, anytime you make me speak on your behalf, there's a way in which you're associating me, and to the extent that I'm going to be associated with that message, it's going to redound to me in some way, so that at some level it's always moral. So that's to, I guess, offer a yes and no. The school funding cases are really, really puzzling. In the voucher type cases, I take it that there's a very liberal thought that's going on the part of the court, which is, look, the state isn't deciding to subsidize the schools, it's the parents who make the choice, right? So once you have parental choice, that exercise of autonomy obviates any connection the state might have. I think the more difficult cases are the direct aid cases, right? Like now we're funding textbooks, and we're funding playground service material, but surely that's freeing up money for religious instruction. So why doesn't fungibility work in the establishment clause context the same way it works in the material support context? And my conjecture there is that the state just doesn't want to have to entangle itself with the school such that it traces the money through the school's books, that the need to monitor where the money is going would involve state entanglement, which up until this past term was a no-no under Lenin. And that's the reason why we don't see the court acknowledging that there are fungibility concerns in this context. But I want to do much more thinking on that score. I think that the school funding cases do pose a real challenge to the analysis.
Professor Chapman?
Nathan Chapman. I want to follow up on Rick's point about funding. If it's a historical question that has perhaps implications for the trajectory of these doctrines now. So I could be wrong, but I just don't recall cases in which the court articulated the same kind of concerns about complicity through funding before Everson and the cases that led to the Women doctrine. And the court has abandoned that doctrine now
on the grounds that it actually was in part, I think, a mistaken understanding of the original complaints about coerced ties, which they were against coerced ties. They weren't against using taxpayer dollars to fund religious institutions that were forming civil good and public goods generally. So that accounts for the court's about face with respect to the Establishment Clause and spending in the recent cases. If that is right, if it is the case that the court's whole theory about money connecting people in their conscience and their own life was based on this misunderstanding of founding era that got incorporated into doctrine through Ederson, might it be the case that we'll start to see an unwinding of that as the court backs away from it in these cases?
So is the speculation that claims like Hobby Lobbies might be less well received because money is not implicating given the
Maybe so.
development?
I happen to think a lot of these cases can be explained by the whole doctrine the court's applying. So like in Hobby Lobby, it's a statutory case.
Right.
It goes about the process of looking at other exceptions the first line. But in general, in other speech cases, for instance, where the court has associated equated speech and money, you think if it's abandoning it in one area, it will abandon it in the others?
I'm not hopeful. I think the court is very keen to, in the campaign context, it's not retreating on the claim that money is speech. I don't think it's going to retreat on the material support cases either. So maybe what ends up happening is religion in some sense gets carved out as special. Yeah, I mean, remains to be seen.
All right, we probably have time for one or two more questions before closing remarks by Courtney. Yeah, Professor Koppelman.
So I want to ask Paul a question. You are uneasy with Habermas's idea that there is more of a constraint on the formal political sphere, on political actors. And I've written about this. What do you do if an argument is made to political actors that you should do something and you should justify it on religious grounds? So, for example, it's a case, verse in Loving versus Virginia, where the state prohibited interracial marriage on the justification of the trial judge. Argument was under legal review. He offered as a justification for the statute, Almighty God created the races white, black, yellow, Malay, and red and placed them on separate continents. The fact that he separated the races shows that he did not intend for the races to mix. Is the court to assess this for its theological sacredness, or what should a court do? It's presented as a reason for a state official to make the decision that the state official makes. In this case, well told, and otherwise in constitutional law.
So let me check I understood, Andy. So the thought is, so is this meant to then be an objection to the Habermas type view because?
Well, it actually is the support for Habermas view, which you expressed some uneasiness about your paper.
Oh, so why is it in support of the Habermas view?
Because I think Habermas would say, religious arguments in public discourse, popular discourse, you can say whatever you want, can nourish the residents. But when a public official makes a claim, you cannot justify state action on the ground that thus it is laid down by Almighty God. State officials are not to argue theology with another.
Yeah, good.
Appropriate role for state officials.
So I take it Habermas's view has a further element, which is the thing that I express uncertainty about, although I just I don't know what I think about, which is, so we can distinguish three things here, I think, right? So you've got this distinction between officials and citizens, or roughly, right? And I think there's a third category. So you've got citizen discourse, you've got official discourse in the sense of the state telling us what it's done and why it's done it. qua kind of speaking in the name of the state. And then there's the discourse of elected representatives. So what people say in Parliament, what people say, you know, around the cabinet table.
I was thinking of the official discourse of the state.
Right, good. So I think you're right, and Habermas is right on the official discourse. So when the state stands up and says, we've enacted this law, we've made the decision, this is why, I think there are good reasons and good grounds to say that that shouldn't be the this is why shouldn't then lead to some religious argumentation or religious claims. The question I think that I'm not sure about is the middle bit. So Habermas has this line where he says, if an MP in Parliament says something religious, it should be scrubbed from the records, right? So in Britain, we have Hansard, which is like the transcript, everything that gets said. And Habermas's view is like, you should cross it out, pretend it never happened. And that's the thing I'm unsure about, right? So the Habermas is right that there's a distinction here, and there's a point at which religious justifications become impermissible. But the question is where that line is. And I think he might put it too early in the process, if you see what I mean. Does that make sense, Andy? So I can't see you, so I don't know if you're...
All right, thank you. Can we bring up Courtney Claus, our own Courtney Claus, to finish off with a few remarks?
I'll be brief so everybody can eat. I just wanted to say a great big thank you to everyone for coming. First of all, thank you to the Emory Center for Law and Religion, as well as the Church, State, and Society organization here at Notre Dame for helping sponsor this symposium today. Thank you all for coming to Notre Dame Law Review's Issue 4 Symposium on Liberalism, Christianity, and the Constitution. Just after this, we will be headed up for lunch in the faculty meeting room. Our authors, as well as Law Review staff members, are welcome to join us. And there will be a keynote speech given at the Morrison Ballroom later this afternoon at 1:30 that our symposium has been invited to. This is a part of the Center for Ethics and Culture annual fall conference that will be going on later into the weekend. Before I go, I'd love to just give a round of applause for all of our authors for coming here and for participating in the symposium. Thank you so much. And with that, have a great afternoon, everybody. Thank you.